Pardon, my lord. I may be pardon, my lord. Item 68.
Yes.
Item 68 is a special court act. He has been convicted by the Lawrence Special Judge, Special Court Cuttack. Even though all the special court matters have been assigned to Mr. Simon Das, but this particular matter has been entrusted by the department to me last week only.
What do you want?
Last week only. So I want that I pray before your lordship that
Okay,
let
I'll
it be
mark it
taken up
and keep it. Let us see who is coming from the other side.
in the first week of September, my lord, let it be listed.
No, it is fixed at 2 p.m. it seems. Yes, 2 p.m. special matter.
In the first week of September, I will get myself prepared and written note, etc.
That's right, sir. It is fixed. I'll mark it and let us see who is coming at 2 o'clock from the petitioner side. Then I'll let them. Okay.
I pray that this has been entrusted to me last week only. Last week.
How can I do it? It is specially fixed matter.
2 p.m. That's right.
Okay, my lord. Okay. If I'll be available, I will go and I will attend your lordship.
Item 4, my lord.
Yes.
Item 4. Let it come Monday, my lord.
Monday, if you ask for adjournment, it will. Don't ask before that because
My
we are adjusting the list accordingly.
My lords.
So asking for something, then we go to September.
My lords.
Put it in September.
Number 85, my lord.
80?
85.
Yes.
On behalf of Mr. Satyendra Padilla, suffering from fever.
85. Who is the other side? 85.
Hearing matter. Hearing matter.
Vigilance.
Pattern to
The whole
mention.
matter 85.
Item 6, my lords. On lordship's board item. Lordships had directed us to remove defects, my lords, perimetrally on 2nd of August, my lords. My lords, we have removed all the defects and I have filed an IA for exemption of from filing of the certified copy. In the meantime, my lords, as per instruction received today, my lords, I'll receive it by today in the
What do you want?
I paid 1 week after that.
No, you tell the registry if peremptory order is passed, I can't keep on.
I complied with the order. It's I
Compliance
pray
is-
pray for an adjournment to file the same.
Let us see what is this matter. These matters are unnecessary. There is nothing. These matters.
Pattern to mention item number
Yes.
66 permitted to withdraw.
6.
66.
66 withdraw.
May I be pardoned to make a mention, my lords? Lords, I had filed a CLMC bearing number 1376 of 24 minutes, wherein I had filed an IA seeking certain appropriate direction / modification, my lords. It may be
Come
called,
in the lines, queue.
my lords, now the roster lies with Honorable Justice Aditya Mahapatra, my lords, and the matter is unable to be listed there because of this pending IA before, my lords. Lords, tomorrow I can.
No, if that assigned to that bench, how can I hear I will be heard?
I had filed that IA when it was pending before my lords. My lords may call it tomorrow. I can
No.
press it.
I can't call because it is assigned to some other bench. I can't do that.
My lords may allow me to not press that IA at least. It was filed.
The main matter is assigned to some other bench.
My lords.
In that main matter, you have filed an IA.
That when it was pending before my lords, before this court, my lords.
If the main matter goes, the IA will also go there. Assignment is not dependable on the basis of interim.
Now the listing has asked me to mention before this.
How can I entertain the application? It is not assigned to me. How I can't do
Now
that?
because it was filed for modification of my lord's order.
Registry may say something, anything, but I can't entertain a petition which is not in my assignment.
My lords.
I can't entertain somebody. Then you mention some writ petition. That also.
It was my lord's order for which I was seeking modification, for which it is pending, my
There
lords.
is a limit to all these things. Go and do the registry. Yes. Yes. If they list it, I can see.
They're not listing it, my lords. It's been a week. I'm done it.
Might have asked them. Yes.
Item number 6. If your lordship may take up as the last item. I know. I know.
You can assess it at 2 o'clock only.
I'll try my.
Let us see if
Because
code is adjusted. I'm interested to take
because
up.
your lordship had substantially heard from my side
Let us
when the
see.
vigilance was to
Well,
answer.
if the time permits, then I'll hear it. No problem. Okay. Yes.
Item 1.
Yes.
May I please? Hello,
Yes, sir.
listener. But here the case is that a case was registered under section for the civil dispute. The case was registered under Annex 1 FIR 354, 323, 307, 149. It's a civil dispute that they are trying to while they are
You are against the cognizance order.
cognizance.
Show me the charge sheet.
Charge sheet is under Annex 2.
No,
But I'm first briefing the case.
Yes. No,
Case was registered.
I'll have to see the.
My lord,
Don't waste time. Yes.
This is charge sheet, my lord. 307 charge sheet while
No, no,
submitting charge sheet is 307 was exonerated. He was my lord, your lordship running page 13.
What are the allegations against?
Pardon?
Let us see what are the allegations against you.
My lord, I'm reading the allegation, my lord.
20,
Pardon?
23.
Charge sheet is, my lord, running page 13, Annex 2. Start
Read
from
this. Read the relevant party
My lord.
part.
allegation that on dated let's one so the village written a report that before proceeding effect that our
Have you are ready it or now you are trying
no,
to
I'm
read it?
ready, man.
Now you are ready?
Pardon?
First time you are reading this thing here.
No, I'm ready.
Now, have you read it earlier? I'm asking you.
Pardon?
Have you ever read this page earlier?
My lord.
Or you are trying here?
Handwriting, that is why.
Yes.
That the accused persons Narar Sethi, Dinabandhu Sethi, Kamalendra Sethi, Iswara Sethi, and so, forming unlawful assembly with deadly weapons, assaulted him, causing injury on him person on protest by his wife. And
You are
daughter.
Narari. You are Narari.
I'm Malat.
You are Narari. I've seen.
Narar. Malat.
And do you need to read further?
I'm
For
Narar.
cognizance. For cognizance, is it not enough?
I'm coming, Malat. Why this is the FIR allegation, but police submitted charge sheet deleting 307.
No problem.
Then, Malat, what happened? Magistrate, Malat, this petitioner, he was granted bail by this honorable court. He appeared and granted bail. Charge sheet submitted. Cognizance was also taken, not for 307. That is the case, Malat. 307. So, Malat, when the case was that, material was there, magistrate applied his judicial mind, he took cognizance. What happened, Malat? Thereafter, Malat, APP, London APP, he filed under Annex 3. He said that since there is an allegation, again 307 should have been added. But how this magistrate has the jurisdiction? Once he took cognizance, it's a final order. Can he, can he take again another 1 second?
What happened? Charge frame.
No, hey, cognizance.
Charge, you have to argue all this thing in charge.
He cannot take cognizance twice.
Has he taken cognizance twice?
Yes, that is why.
Yes.
He took cognizance.
Where is cognizance? Second cognizance.
That 4, Annex 4 is the impugned order. Impugned order, Annex 4.
Show me the earlier cognizance order. Earlier cognizance order. I'm challenging the
You show
order,
me the
impugned
first
order.
cognizance order.
You said twice he has taken.
That is mentioned, That is mentioned. That is
show
why I'm
me-
ready.
Sir, you show me the first order.
First cognizance order.
Huh?
First cognizance order is not with me because, but indeed mentioned in this order, impugned order,
Why are you
detailed order
making
is there.
misleading statement? This is the only cognizance order taken.
No, second I'm challenging the second cognizance. Second cognizance.
Show me the first cognizance order.
First cognizance order, my lord, it is mentioned in the, my lord, paragraph 2, running page 25, Annex 4.
Yes, Mr. What?
What happened in this case, my lord, actually, my lord? The case under section 307 and other offences, allied offences registered, my lord. Subsequently, charge sheet submitted the IO deleting in the offence 307 IPs, my lord. While the APP, my lord, gone through the record, came to know that 307 is clear, my lord. Thereafter, he filed a petition before the concerned court, my lord, under section 190 subclause E, my lord. C, my lord, C. C says, my lord, upon information received from any person other than a police officer, upon his own knowledge, that such offence has been committed. For that reason, my relying some decisions upon appeals court, my lord, the court will taken cognizance, my lord, added 307 only.
Yes.
Added 307. Since there are against 5 persons, my lord. This man Malad came forward only alone
No, no.
saying that this is
I'm-
illegal.
Another thing,
That
another
man,
thing,
Malad.
take care, sir.
190E. A said that upon a receipt of a complaint, so for a complaint case is concerned. Second, police report such facts had Malad. C.
Often
upon
information
receipt
received from any person other than the police officer,
AP filed the petition.
or often his own.
Illegality.
Yes.
My lord,
But he can raise all this point at the time of.
how? Framing of what I'm managing. These petitioners, my lord, all the petitioners, my lord, your lordship kindly have a glance in the noting, my lord. This case, my lord, initially this is a case of 2003, my lord. I filed 2003 and challenging that order, my lord, I filed a CRLMC petition. And this honorable court told that once, my lord, because 323 says that during course of trial inquiry, if it comes to the magistrate that some other offences has been committed, then he could have, there is occasion on the, my lord, under section 320 of the magistrate to commit the case once it comes to the knowledge. He cannot take cognizance twice.
How many injuries caused by you to the victim?
I have not, my lord, assaulted, my lord, all omnibus.
That's the
The injury report.
I understood.
No,
You think that I don't understand things?
I'm coming, my lord.
You are
So many
speaking
things.
simple English.
In 2004, I challenged the order of cognizance.
There are
This-
5 injuries received by the victim, and you were assembled with armed everything to assault this man. You have assaulted, and thereafter the FIR was registered. Investigation has taken place. Despite the fact that 5 injuries were received, police, for reason you know better than anyone else,
It is better
yes,
no.
left that
Well-
particular provision. So therefore, since materials were available, 190 application, 190C application was moved. Even in the absence of 190 application, the
So-
charge could have been framed under the.
That I'm the, here the question is sole question. I filed a CRLMC petition in 2004, challenging one question, only sole question, whether magistrate, once he took cognizance, has the magistrate jurisdiction to take cognizance once again? The case was, my lord, relied by this honorable court in Govind Kumar case. Thereafter, this honorable court, my lord, referred the matter to the division larger bench for consideration as to whether the magistrate, because in the Adalat Prasad case, this Supreme Court has, Honorable Supreme Court has decided that magistrate has no jurisdiction. 362 is bar. It is a final order. He cannot alter his cognizance. So once he took cognizance,
Paragraph
my
10
lord,
is
no,
important.
complete.
Paragraph 10 of the
8 and 10.
8 and 10.
So once, my lord, he took cognizance, he cannot alter, my lord. It is recourse is upon him, and to add an offense accused on 319, to add offenses come out during inquiry. 323 recourse is there. So he cannot take cognizance twice, my lord, because he cannot alter his own cognizance. Because Adalat Prasad case, my lord, is clearly, my lord, laid down this. So that is this honorable court, my lord, is refer the matter to the larger bench. When the matter is sub judice, my lord, pending.
What about the judgments relied upon by the
No,
court?
no judgment was, my lord, in 2019 when the matter interim order was there. My application.
What are the judgment? Have you read those judgments relied upon by the trial court?
Yes, I have, my lord, I have read.
How will you distinguish those judgments?
Distinguish because he has not taken into account distinguished, my lord, the Govind Kumar case, because 323
Where
recourse
are
is
the
available.
judgments? Where is Govind Kumar?
Govind Kumar case has been, but because if your lordship will see the order, my lord, file has come in CRLMC number. If your lordship kindly have a glance, CRLMC number.
You are only arguing on air. You
No,
don't
no,
write it.
air name.
Show me any judgment, sir. How will you distinguish the judgment cited by the trial court while passing the impugn order? He cites 3-4 judgments.
My lord.
2002, 22 OCR, that is the Sridhar and 2 other judgments also he has cited. How will you distinguish those?
I will, sir,
Have you gone through those
I
judgments?
will distinguish everything, your lordship.
And give
CRLMC,
time.
sir, CRLMC number 1214 order टीसीटा टे देखंतु आसीची जोटा फाइल टा टैग है 1214 your lordship में I will argue on
1214, yes.
with yes.
नहीं 1214 नहीं 266.
नहीं 1214 is 266 होची तार से dismiss for default हेतिला सेति मु सेटा तापर dismiss for default पर से ऑपरेशन हला CRLM CRLMC 1214
No, 1214, yes.
Achhi, with
Yes, yes, yes. Tell me, what do you want to show
in
me?
that case, my lord,
Hmm?
this honorable court refer the matter to the larger bench.
Huh?
Refer the matter to the larger bench for adjudication regarding this issue. And
Hmm.
while the during pendency of this case,
Hmm?
this case was my lord, dismissed for non-prosecution. Thereafter, I filed a CRLM and that was restored. That is restored, my lord.
What
There
is
was a
this
stay-
266 of 3?
CRLM, such a restoration petition.
Where is the main matter then?
Main matter 1214.
That's not there. That's not there.
1214 of 2000.
1214 is not there. Huh? Show me. That order is not there. Yes. But this is none appear, this much it has come.
Restoration, sir.
That's right, but you say that it is referred to a larger, that order.
CRLM, it is CRLM 1214 if you also will see. CRLMC number, it is a CRLM. Restoration ta say order ta restore hela. CRLMC number 1214 of 2004.
That file is not there with me. That's what I'm
Noting
saying.
re ଅଛି ଯେ with ବୋଲି ଆସିଛି.
You have to come with all this paper, no?
But
You show me that order.
But,
How, where it is referred to a larger bench? Show me.
ଏ order ଟା ଖାଲି ମୁଁ download copy ଟା ଅଛି. ସେ file ଟା sir with ହେଇକି ଆସିଲେ ସିନା. ଏଇ CRLM ଅଛି.
What is this question? What is referred? Nothing is there, one line.
Refer ଟା ତା ପୂର୍ବ order ଟାରେ.
Adjourn to next week. You are not prepared.
Well, this order CRLMC भी कम है. 1214. No,
You have to show me that order by which it is referred to a larger bench. You say that this, in your matter, it is referred to a larger bench. You show me that order by which, show me the question of law, what is referred. I am not agreeing with you at this moment. The impugn order is absolutely correct.
Pardon?
Impunity is absolutely correct. Even if it is not correct, it can be tested in the stage of framing of charges. You can raise all these points.
My humble submission, magistrate had no jurisdiction to.
You have already told that.
Bas.
You have already told that. Don't repeat. There are two options. You can raise all these points because if the wrong cognizance is taken, 307 is made out or 307 is not made out, all these things can be tested at the stage of framing of charges. You can have all the liberty to argue.
No, that liberty.
I was about to pass that order, but you said that this substantial question which according to you, you have raised is referred to a larger bench. Show me what is the substantial question framed. Whether this the question which you are raising in this petition, whether it is referred to larger bench, then I can't touch it.
Sir, ये जो CRMC सर मु एबे फाइल करछि जण पई एटा 2004 रो फाइल टा नॉन प्रोसिक्यूशन डिसमिस हला बोली मु जण पई आउ थरे फाइल करथिली किंतु कोर्ट कहले ना जेहेतु अर्लियर पिटिशन टा नॉन प्रोसिक्यूशन हेछि सेम ऑर्डर टा आपण
I understand that. Don't you think that I am so dumb a person that I can't understand?
Certainly not.
Where is the main petition which was referred to larger bench got dismissed in default. Therefore, you restore it. I understand that. Where is the main petition? Where is the order?
सेटा आसीले फाइल सर
I will have
14 टा पुट अप करेले
adjourn it for next week. Next.
12 along with मतलब 1 to
You get that order.
Pardon?
It is your petition. You get that order and to give me.
well फाइल टा with है कि ना
File is already called and they are sending this
Only order sheet.
application. Yes.
Order sheet is with me मतलब other orders there is a stay order was granted this
Next week I am.
No.
You are not prepared. You are wasting time on it. Number two. So, come with all the judgment. Come with all the reference which is made. At least you should be armed with this thing. And two judgment referred by the trial court. Show me those judgments. And you want to distinguish that also. Show me that judgment of.
next week रखाओ next week also fix है and your lordship may call for the registry to call for that file original file otherwise 1216 file टा
Call for that.
आइए
Come with all judgment. Don't make
I
piecemeal.
have come with my lord all judgment. One thing is that unless that original file is come, my lord, that is
I have called it. Yes. Next.
My lord, next week, my lord.
Yes.
May I please? The last the petition of the lady challenging the order dated 21/4/2023 with regard to the cognizance were taken against the petitioner.
Yes.
The last there is the allegation of 306 and the FIR allegation the case has been registered against 3 persons and 2 unknown persons. While the investigation was completed, after completion of investigation, the IO has submitted the charge sheet, discharged all the accused persons, and only the sheet has been submitted against the present petitioner. In fact, on the day of occurrence, the petition was not available in the spot house, Lordship.
You are the wife of
Wife of the one of the accused, the
But,
petitioner and the
The petitioner is the sister-in-law of the deceased.
ନାଇଁ ନାଇଁ ଶାଳୀ ନୁହଁ ଏ ଯୋଉ ଶଳାଙ୍କର ସ୍ତ୍ରୀ ଡିସିଜରେ ଆଉ ଏ ପିଟିସନର ଦେ ଆର୍ ରିଲେଟେଡ୍ ଟୁ ଇଚ୍ ଅଦର
Let us see the charge sheet, whether
Lordship,
allegations
Lordship,
are there, then
Lordship, Lordship.
cognizance is rightly taken.
Lordship, Lordship.
Charge sheet.
Charge sheet running page 29, Lordship. The relevant portion, Lordship. Lordship, I'm reading over. The IO has visited the spot. The third start the relevant portion, Lordship. Visited the spot in presence of a scientific team has identified the complainant in presence of the witnesses. The spot of the case is located at the first floor residential rented house of the accused Mittu Podiali. Mittu Podiali is the husband of the present petitioner of Trupti Nagar, Third Lane, PS Badbazar, Barampur, which is 2 kilometers west to PS. The spot house is consisting of 3 rooms, 1 kitchen. The spot house of U Uma Mohesh is located east of the spot house, and house of the Jyotsna Chaudhary is located opposite of the spot house, opposite to the road. During the spot visit, no incriminating articles found from the spot. Thereafter, Lordship, the cause of death is in the death was due to combined effect of asphyxia and venous congestion as a result of antemortem hanging.
Any suicide note?
Lordship, let's kindly glance running page 58. I will annex the some 161 statements, Lordship. No suicidal note is there. The family members are stating there is a love relation, some amount is transaction was made.
Yes, Mr. Raghuda. What are these material against this
The
lady?
material, my
Because
lord,
the husband and everybody is let off.
what had happened in this case, my lord, on the particular date of occurrence, my lord, the deceased went to her house, my lord, and asked something, some money transaction there between them, and demanded the deceased demanded money. Thereafter, there is a quarrel between them, my lord, and deceased having the petitioner having 2 children, my lord. He went away with 1 children to a temple. By the time this another son of the petitioner was in the room, the occurrence taken place in the house of the petitioner, and by the time when the petitioner and one son went to the temple, by the time there is a quarrel, by the taking that opportunity, the petitioner entered into the house of the petitioner and hanged in the.
But the fact is the suicide has taken place in her house.
Their house, my lord. And one son was there, his evidence also recorded. He stated that ମା ପଳେଇଲେ ମନ୍ଦିରକୁ ମାନିଲେନି ତାଙ୍କର ପ୍ରାର୍ଥନା ହେଲା ପଳେଇଲେ ମନ୍ଦିରକୁ ତାପରେ କୁଶା ଘରେ ପଶିଗଲେ ସେଟ୍ କଲେ presume that my lord, the might be my lord, the behavior shown by the petitioner, he committed the
Have you implicated the informant?
my lord,
Lordship, I already
Issue
implemented.
notice, let us see. Issue notice after 1 week. You file a status report. This is very harsh case.
Till then, no courage, Lordship.
No.
Lordship, the lady, Lordship.
For bail, you have to go to some other court. I am testing the cognizance.
What is Lordship?
Don't waste time. I will not do it.
My senior has stated that there is some financial
But if
transaction.
you filed, I have issued notice, that means you have a good case for cognizance.
Yes.
So therefore you apply for bail, you immediately get it. What is this? Yes.
I can see business matter. Business.
Nobody said. Next week. Board is very heavy today.
Next week.
Next week. Okay. No need to of the.
time नहीं है ना?
Another item, business matter is there.
For your, some of your friend have mentioned
Don't mention time में adjourn करिए.
and told the court that I have intimated the other side.
हाँ. ठीक है sir, निकल रहा है. I don't know for
My lord, this is independent. First time this matter was listed.
time passage.
You are appearing for petitioner.
I'm for the petitioner and first time the matter was first.
Who has mentioned? I don't know from your chamber. How do I know?
My lord, mo to eka mo chamber
How you know sir? Yes, Chandran sir. I don't get time.
My lord, wrongly someone has taken time, your lordship.
What is this matter, let us?
Oh, my lord,
Huh?
who has mentioned my lord? His item number is 5, but he mentioned item number 4. Mr. Dhar. Mr. Dhar. Devendra Kumar Dhar.
There might be a mistake.
My lord.
Argue, you have matter. You.
Lord, the two petitioners are there, your lordship. They pray for quashing of the criminal proceeding on the ground of parity. Because,
Ground of parity.
yes, your lordship. In this case, your lordship, page 20, your lordship.
Any other quashing is allowed?
Yes, your lordship. Judgment has been passed by this honorable court. Your
My lord,
lordship.
can I say flag 2, my lord?
First,
Flag 2. Earlier, my lord, 304 CRLMC, 304 up to round 3.
yes.
My lord, one of the, I have annexed the judgment copy. That is-
Sushant Kumar Samantarai.
My lord, Sushant Kumar Samantarai, your lordship. Your lordship, kindly see the page 20 last paragraph, your lordship. Page 20 last paragraph. Cognizance has been taken by the learned magistrate against the 5 person, your lordship. Out of 5 persons, 2 person has died, your lordship, in the meantime. And proceeding for 1 person has been quashed by this honorable court. And before your lordship, other 2 person.
That is quashed in September 2013.
2013, my lord. 2013, your lordship.
The cognizance taken when?
Cognizance taken, your lordship.
That is
2000.
8/6/2000
My lord,
and 8/6/2000.
my lord.
And what is the stage of the trial now?
My lord, matter is posting for appearance after taking cognizance.
After in 2000,
Yes, yes, lordship.
2000, the
Yes.
cognizance is taken today, still at the stage of appearance.
Yes, yes, lordship.
24 years.
Yes, lordship. Your lordship, kindly see.
Submitted showing them absconded.
You are
No, no,
absconding.
no, no. The petitioners were arrested and they were on bail.
Since
No,
legally
no,
for the appearance.
No,
he's
no,
saying.
no, no, man.
Bail
That-
ଅଛି?
हाँ, bail ଅଛି.
Appearance କହିଲେ ପରା?
No, no.
What is
That's it
this?
for appearance by date. First appearance.
What is this happening?
Your
24
lordship-
years,
Yes, lordship, kindly see the page 22, your lordship.
22.
23.
Yeah, no, that's-
After passing of the criminal proceeding against the 1 person by this honorable court, first time the matter was posted to 10/12/2021 for appearance, your lordship,
21.
my lord.
Thereafter,
Thereafter, they came before your lordship. After receiving summon, your lordship. Someone was not,
25/8/2021.
my lord.
That is page 22.
Page 22, yes, your lordship.
21. Now you are, we are in 24. Now you are coming.
No, no, in the year 2020, after sufficient of summon, they came to this honorable court, your lordship, in the year 23. My lord, the judgment is squarely covered to these petitioners also, your lordship. Kindly see the page 20 last paragraph, your lordship.
Hmm.
Thus, considering the nature of facts and circumstances and after going through the records,
Offenses?
my lord, 304 part 2 and 149 IPC. I am placing your facts of the case.
Yeah, are you ready?
My lord. No, my lord, I got the case record, my lord. Case record.
Get the case record. Oh, list it for finally so that.
My lord,
CD record.
my lord, case is posting for appearance, your lordship. 1 person is in service, your lordship.
24 years, nothing has happened. Now what will happen? Yes, next.
Item 6.
My lord, date.
Date he is giving. Get ready.
My lord,
This
CD
is a very harsh case. 2000 cognizance, 2013, one accused cognizance order is quashed. Now, after 24 hours, 24
20
years,
years.
what will you do?
My lord.
Better to quash it.
Verify
Finish
the
it.
record, my lord.
Yes.
Item 6.
Item 6, my lords, I filed an IA for exemption of filing of the certified copy.
Yes.
That is the impugned order, my lords.
Yes.
Annexed 2.
Hmm.
I have
And what is this matter is about?
petitioner challenges the cognizance, my lords, thereby of offenses
354A, 354B.
B 109 and 34 of the Indian Penal Code. my lords.
Show me the charge sheet.
I have lordship's permission, my lords. I have the certified copy, my lords. Both the present petitioner and the complainant were employees in the same bank, my lords.
Hmm.
It is, the complainant had secured a job late in the year 2022 minutes. Thereafter, after joining for few days, she voluntarily did not turn up in the office. For which, my lords, Annexure 3 and Annexure 4 are relevant. VAS.
What have you done?
It is alleged that on the
What is
relevant day,
allegation?
my lords, on the relevant day,
Hmm.
as per the direction of the manager, one Padmavati, another accused person, asked the informant.
What is your name?
Jyotirmay Mandal, my lords. ଦିଟା pending ଅଛି। ହଁ sir, କହୁଛି।
Do you have 164?
FIR clear ଅଛି।
It is stated
ମୁଁ
that
ମୋର ଡ୍ରେସ ଚେଞ୍ଜ କରିବାକୁ ରୋଷେଇ ଘରକୁ ଯାଉଥିବା ବେଳେ ସେଠାରେ ଜ୍ୟୋତିର୍ମୟ
dispute per se
Let's
employees,
see.
my lords, that being the
See,
background.
Harassment of women in the
Admitted, my lords.
workplace. And the High Court is suggesting to settle the dispute, sends a very wrong. So therefore, better you withdraw it and argue all this point at the stage of.
Can it be simply adjourned, my lords?
No, I will not adjourn. Don't ask. See, the dockets are so heavy. Why should you adjourn? Right. Petitioner has challenged the order dated. Where is the order? Order
Annexure
dated,
2, 24 to
20th for 2023 passed by the judicial magistrates first class, whereby the cognizance for offence under section 354 capital A, 354 capital B, 109 and 34 IPC has been taken against the petitioner. There are specific allegations made against the petitioner in the FIR and the statement for the victim under section 164 CRPC. The petitioner, by relying upon various documents, tried to persuade this court regarding the false implication for the petition. Even if the false, I'm afraid that at this stage, I can consider the documents relied upon by the petitioner, to test the legality of the cognizance. Therefore, I am not inclined to entertain this petition. However, the liberty is granted to the petitioner to raise point before the trial court at appropriate stage. If such issues are raised by the petitioner, the same shall be considered on its own. With this observation, the petition will be. Yes.
Great, please.
7.
Yes.
7, my lord.
No?
Quashing, my lord. Cognizance.
Cognizance.
My lord.
Non-APS. Non-APS for the petitioner in the interest of justice.
Item 8.
Because today passing it over makes no sense. 80-90 matters what to do.
My lord, may I please? Your lordships may keep it some other day because they are residing husband and wife, my lord. So I will produce the victim and the husband.
What is the offense? What are you
Offense,
asking?
my lord, 3761 because he was not married, for which this victim has lodged the affair.
Yes.
Subsequently, they have got married. I also annexed the.
They married now.
ସେମାନେ ରହିକି Aadhaar card ये भी मैं annexure କରିଛି. So I will produce.
Aadhaar card?
They are now residing and Aadhaar card and election card also reflected the husband is this petitioner, my lord.
Shall I record that you have already married?
I have annexed, my lord.
Where is
So
that?
your lordships keep it some other day. I will produce both of them so that it can be decided.
Right. You are challenging the order dated.
Order of cognizance, my lord. Order dated
In this petition is
uh,
challenging the order dated
18/4/2020.
2020, passed by learned JMFC
Vasudev.
Pur in GR case number 94 of
Okay.
2020, arising out of the Basudevpur PS case number 2020, and 2020, whereby the court below has taken cognizance of offence under section 376 bracket 1 of IPC against the petitioner. Then counsel for the petitioners submits that the petitioner and the opposite party number 2 has now married and happily residing together. Since the parties have settled the dispute, therefore he seeks indulgence of this court. And have you filed the joint affidavit?
Joint affidavit, your lordship, direct for appearance.
I will not direct.
I will produce, my lord, your lordship.
Issue notice to opposite party number 2, written evidence. Yes.
What date, your lordship?
He'll give next week immediate week.
Obliged.
Nice, yes.
Item 9.
Yes. Yes. Yes.
9, my lord. Passing, my lord.
Passing of cognizance.
My lord.
November 20.
Impute order dated 20th 11 2023.
None appeals for the petitioner in the interest of justice. Yes.
Item 10. My lord, only petitioner. They have not supplied any annexure, my lord, only petition.
They have filed only cognizance order.
Cognizance order, petition. Even if cognizance order not given, my lord.
Huh?
Cognizance order not given.
11, huh? Item 11.
10.
10.
Only petition, my lord. So they have supplied only the petition, copy of the petition.
What is the cognizance order? Cognizance under section what? 328. Petitioner is challenging the order dated 16/11/2023, whereby cognizance for offence under section 420/34 IPC has been taken against him. In the present petition, except to the cognizance order, nothing is filed. Nothing is filed. Neither the copy of FIR nor of charge sheet. Copy of charge sheet. Charge sheet. So 2 working days granted to the petitioner to place on record the relevant document for the purpose of adjudication of the present case. In the event the petitioner fails to place on record any such document, the petition stands dismissed. Petition shall be dismissed without reference to the court. In the event he files the documents, release the matter. Yes.
Item 11.
Again, the case. But here, well, at this point, my lord, Mr. Maharana had taken time to 29.
29.
That departmental proceeding vis-a-vis criminal proceeding.
29.
Well,
Release it on 20.
But if any application will be filed, like a date posting, that
Where is the date?
that ballot it was there and it.
Is it there before
And he is the
29?
petitioner is in hospital for which I did not, for operation, some operation he is in hospital.
Release the matter on
29th,
29th also. In the eve, trial court takes up the matter before this day, the petitioner can seek an adjournment. Yes.
Item 12.
Well,
Lordship, on behalf of Mr. Chan, Lordship, kindly adjournment. Praying for adjournment, Lordship.
why sir? Why?
Item number 12.
On the petitioner submits
Sorry, Jugal is.
Application is pending last years. In the meantime, the witness have already examined few of the members of the. We have also You want to place on record every 13 into this. See, you are supposed to file the evidence up of PW 1 to 13 within 2 days. Have you filed it?
Yes, filed, my lord.
My lord, possible.
Maybe for court.
Yes, filed it. This is for quashing or what? This is bail or quashing? What is it?
Bail, my lord,
Bail,
bail.
man.
Bail, my lord.
Bail. Yes, pass over. Pass
Mm,
over.
pass over.
Yes.
13.
Lordship, beg your pardon, Lordship, item number 10, Lordship.
You were there in 12.
I mean,
I have passed a peremptory order. You comply that. I have not passed any adverse order.
Lordship,
I have only said that you have not filed charge sheet, you have not nothing.
Lordship,
Except a
kindly-
copy of 1-page order taking cognizance. There is nothing.
Lordship, kindly allow me 1 day of time. Lordship.
I have allowed
I'll-
2 days. I have allowed 2 days.
Okay.
Not 1 day.
Deal.
Yes. 13.
May I please, your lordship? Madam, I am for BLAPL 14039 of 2023,
How
madam.
many PLFPL?
Two
Yes.
BLAPL.
PLFPL
14039,
Yes.
my lord. The petitioner name is Timuru Hon'Ble, my lord. And allegation against the present petitioner is that on the date of occurrence, my lord, 3 persons standing near the house of the present petitioner, my lord. On seeing the police, being seeing the police, they fled from the spot, my lord.
Recovery, you tell me recovery.
My lord, 540 from other accused persons.
545.
After seeing the police, this petitioner has fled away from the spot.
From the spot.
500?
20
And he
cases.
is the owner of that house.
Custody, my lord, 11/11/2023. Nothing has been seized from the present petitioner, basing
You
upon
will run away, then how will you see? Run away from the spot.
my lord, yes, my lord, basing upon the co-accused statement, my lord, the present petitioner implicated
Yes.
in this case, my
And
lord.
he is the owner of that house, and in front
My
of
lord,
his
in
house.
front of the
Compromise
house and
was,
road.
What about the other accused?
stocked and ready
accused,
for
my
to
lord.
What about the other
trans-
accused?
Your
Harendra Yadav?
lordship, it is the second bail application. First bail application disposed of by lordship under annexure 2.
After charge sheet.
No, sir, disposal of liberty ଦେଇଥିଲେ, move bail application afresh.
After
In
charge
fact,
sheet.
in fact, in the meantime, my lord, the C report submitted. While submitting the charge sheet, C report not submitted by the investigation agency. And last order I have also obtained on
Well, you do have a C report, have you?
No, my lord. Kind of glance to
This order I have. Right?
this order, and also I have the judgments of the Honorable Calcutta High Court I have obtained. On that ground, bail application has been granted.
My lord, may I pray one thing, my lord? My lord,
It's not received.
Not received, my lord, say court.
Yes, my lord.
Potena.
Not received.
Not
but,
received.
Not received from the.
This
that,
chemical.
Not received. You see, R.K. Patnaik's judgment, you see, even if bail is
Yes.
granted, once it is filed, that will be cancelled. It is not received. Not received means the charge sheet is filed because timeline charge sheet. They filed the charge sheet without
The Honorable Apex
chemical
Court also-
analysis reports.
Honorable Apex Court also, my lord, is sitting over the matter, granting bail to the accused persons. In those cases also, this question was read
I
whether.
know. I
Your
myself
lordship,
have
no, your
dealt it
lordship
and
also.
in one of the matters.
Again, your lordship also.
I myself have dealt.
Again.
I myself dealt. What is the position?
No more, my lord, let me allow to take the.
The issue is pending before Supreme Court regarding
Yes,
the
ma'am.
fact what is more
Like that I have
issue
obtained.
or something.
Yes,
It
ma'am.
says that
Mohammed Arbaaz.
filing of a charge sheet, preliminary charge sheet,
Yes, ma'am.
without chemical examination report, whether it is a final charge sheet or not. That is pending because it is contingent. The NDPS case is contingent upon the C report only.
Yes, my lord.
That matter is pending before the Supreme Court, and Supreme Court, whoever goes there, they allow interim bail and refer the matter to that pending case.
Right.
Tag the matter to the pending case.
My lord, 1
These
week.
people are taking advantage of that.
Yes, I'm praying before your lordship. Only 1 week your lordship may allow to receive the
Yes.
chemical exam.
One submission.
Yes, the
What is submission?
Mr. Rahul and Council
What are the item pending?
petitioner submits that see the chemical analysis report, chemical examination report, he still awaited from the CFSL, from the
Mal-
CFSL, FSL,
Yes,
FSL,
yes.
from the forensic laboratory, from forensic laboratory. Yeah, he seeks 1 week time to get the exact status of the thing.
RFSL forum.
Yes.
I would have
My
one
lord,
information. My
my
IA,
lord-
IA for interim bail on the
My
ground
lord,
of
one of the
illness. Aଜ୍ଞା,
free
ସେଇଠି
copy may be supplied.
ଆଜ୍ଞା ସେ ଆଇରେ ଆଜ୍ଞା 4-5 ଥର ଟାଇମ ନେଲେଣି ପ୍ରଡ୍ୟୁସ କରିବା ପାଇଁ ଇନଷ୍ଟ୍ରକ୍ସନ ଟା
My lord,
What,
one free
what has
copy.
happened in the
ଇଏ ଆଇରେ ସେ ସ୍ତ୍ରୀର
No, no.
ହାର୍ଟ ବ୍ଲକେଜ ଅଛି ସେଇ ଇନଷ୍ଟ୍ରକ୍ସନ ଟା ସେଟା
IA
ବିଫୋର ଭ୍ୟାକେସନ ସେଟା ଟାଇମ
That's right, but what is, where is that?
511 of 2024
Why, why interim?
on the ground of illness of the wife ସେଟା
Why?
before vacation for see the order sheets
Have you got any information?
ସେ ଆଣିଛନ୍ତି ନାହିଁ
Put asini.
District
Regarding the
hospital.
health condition
ହଁ
of the wife,
Aଜ୍ଞା.
not received.
ସେଟା
That is-
3-4ଟା ଡେଟ୍
that is also, yes, admit what happened.
What has happened to your wife? Let us
ସେ
know.
ହାର୍ଟ ରେ ବ୍ଲକେଜ ଅଛି ଟିକେ ଅପରେସନ ହବ ବୋଲି ସେଇଥିପାଇଁ ଇନଷ୍ଟ୍ରକ୍ସନ ଟା
Oh, everybody sitting in the courtroom.
ନାଇଁ ସେଟା
must be-
ଇନଷ୍ଟ୍ରକ୍ସନ ଟା ମାଗିଛନ୍ତି ସାର୍ ଇବି ଇନଷ୍ଟ୍ରକ୍ସନ will be come true
Yeah,
then
you must be outsider.
ଆଜ୍ଞା
You are outside.
ନାଇଁ it's a fact मतलब they
That is also I may be.
Next week, another last week,
I
sir.
will take that instruction also, my lord.
by next week ଟିକେ
Well,
ଆଣ
See, how the outsiders are employing this
It's a
tactics
genuine
for
case.
interim bail and
ନାଇଁ it's a
Free hour.
genuine case
I'll take it.
seek instruction this out. Yes.
next week ଟିକେ ରହୁ
Typo? There are some typo mistake corrected. Okay.
ସେଟା order sheet ରେ
Typos.
ଆଜ୍ଞା
Amul type.
ଆଜ୍ଞା
Amul correction for the type. Yes.
may premail or short date
He'll give you date. Yes.
short date
Next.
A possible item to just pass over.
Which one?
Item 12, just pass over, if possible. For 4 years, more than 4 years in custody, the petitioner is a lady, and the all vital witnesses have been turned hostile. Man has directed me to prepare a short note.
Hmm.
I have
PW
also
1 to 13.
period 1 to 13.
Hmm.
Custody since 22/1/2020.
22?
20. 22/1/2020.
Yes.
The petitioner has suffered a lot, and on the date of alleged incident, there was tussle in the dinner house while she was not cooking well, as a result of which
You
the
are talking about your sufferance. You are not talking about the person who has died
that
at your incident.
that is
You
true.
kill someone and now you say that you are suffering.
Yes, that is true. But all the material witnesses have turned hostile,
And what happened, my lord?
and the informant has died in the meantime.
My lord, what happened? That is the main problem. There are charge sheeted witnesses, and who was
13
the
examined.
13.
13 has been examined, and one of them, my lord, once the 164 deposition has been made with the Saita Munduli, not examined, and also his name has not been reflected in the charge sheeted witnesses. And another one, the informant also who has been made 164 statement, he has expired before the trial.
That's right.
The rest of witnesses are declined. First time.
Then it is fake end of the trial.
Man, all the materials have turned hostile.
But this is a fake end of the trial.
But more than 4 years in
Then you will be acquitted.
4 years, lady 4 years in custody.
That's right, but you argue it finally.
My lord,
Trial is over. At this stage,
Then-
how this High Court can get made?
My lord,
Then
4 years,
at argument stage.
my lord, the last time my lord has directed to prepare
That's
short.
right, I have seen it. I have
And
seen it.
4 years in 6 months in custody, any stringent condition.
No,
Well,
what condition? Thereafter, when the
all the family members have turned hostile. My lord, even if evidence of Pedal 4, well, kindly see. Parite Ramachandra Mudili, who has been listed as charge witness, has already been expired 2 years back. But this is Antar Mudili, is the brother
all
of
these witnesses
Material would have turned
examined-
hostile.
examined after your after your rejection of the bail.
But no,
All the
any
13.
well, petition is a lady, she is provided on
Who
the
all are Who have not supported the prosecution case out of 13?
P-double 3 to
3 to
3 not supported, 4
You
not
tell me
supported.
then, 3, 4,
5, 5,
5,
6, 6,
6.
7 I do not know, 8 I do not know, 9 I don't know. After 12 there are the constables and accompanying team.
So 3,
Seizure.
4, 5, 6.
Hmm.
1 minute.
3 to
3,
5 and 9 are metal.
3. Examine on.
Any stringent condition,
September
petition is a
1.
lady. Will appear his day as your lordship. His day of the trial.
Dala the husband talo. Chandramani husband talo mandala.
ସେ କଣ ସେ ସଫଳ ଖାଲି ଭାତ ଶାଗ କାହିଁ ରୋଷେଇ କଲା ବୋଲି ସମସ୍ତେ ଆଉ another thing has come out in the prosecution that the petition and the deceased both were in drunken state. As per my lords, I have complied my lords order. I have prepared a short note. Any stringent condition, he will appear, she will appear in the police station or in the court every day.
All these witnesses, those who turn hostile, have been examined after the rejection of the trial court bail application. You have to go to that court only. First instance, right out. The petitioner is agreed by the order dated 18/5/2022, whereby his bail plea has been rejected. Subsequent thereto, many witnesses have been examined. I have perused the evidence of PW 3, 4, 5, and 6, those who have not supported the prosecution. All these witnesses have been examined by the court after the dismissal of the bail plea of the petitioner. Therefore, I am of the consider since the majority of the witnesses have not supported the prosecution case, and the petitioner is in custody since
22/1/2020.
2020. I am of the consider view that the trial court should. I am of the consider view that the petitioner should approach the court of first instance, and the trial court should decide the bail application, keeping in view the evidence which has come on record and the fact that the petitioner has already been in custody since about 4.5 years. If such application is moved, the same shall be considered as expeditiously as possible. With this liberty, the petitioner is disposed. Yes.
But I may pardon 3 to 9. 3 to 9.
3, no, I've read 3,
3, 4, 5, 6,
3,
7, 8, 9.
3, 4, 5,
6, 7, 8, 9.
6,
6, my lord, 7, 8, and 9.
8, and 9.
I do not know anything about the incident. Who are the material witnesses?
All material witnesses have turned hostile.
And also in the one line more, the informant has also expired as
And it is also brought to the notice of this court that the informant in the present case is also expired.
expired.
Keeping in these things in mind, the trial court should decide.
And also keeping in mind 437 proviso. Hey, what a thing itself. 437 khali gotte line.
Why don't you write a judge a bail order and I'll send it by fax?
I request to my lord. Khali 437 she's a lady khali gotte line likhi diyantu.
If I don't write, she mail them.
ନାଇଁ ଲେଖିଦେଲେ କାଇଁ ହେଲ୍ପ କରୁଛି ଆଜ୍ଞା
Right now, next.
ହେଲ୍ପ କରୁଛି ବୋଲି କହୁଛି
You will get bail now. I have written everything. Immediately you will get bail.
obliged.
May I
Move the
please, Your Honor?
application immediately you will get the bail. Yes. Next.
May I please, Your Honor?
Yeah.
The case is under 498A 306 of the Indian Penal Code, manner,
Yeah.
and the petitioner is in custody since 1st November 2023.
1st November
2023.
23.
Manner.
Yes.
Allegation on the date of suicide manner, the present petitioner was house of the petitioner.
Your
manner.
husband.
Man.
Hmm.
And the postmortem clearly reveals that due to asphyxia, the petitioner
Hanging.
by
Here,
hanging.
madam.
By
Asphyxia
Bolted
due
from inside?
my lord?
It was bolted from inside the.
No, my lord.
Oh.
Chunri se ghare open door open.
Show me.
to antepartum suicidal in nature.
Antepartum suicide. That is the page number 18, your lords.
That's it. Yes.
My lord.
Yes. Show me.
Death may be due to asphyxia, due to compression of the trachea, leading to cardiorespiratory arrest, antemertum suicidal in nature.
Yes. Allegations. Who is the informant?
Informant
Father-
is the father, father, my lord, that
Show
is
me his
page number 14, your lordship.
14, 1-4.
My lord.
Yes.
ମୁଁ ଶ୍ରୀ ଟଙ୍କଧର ଜାନି ପିତା ସୋଏନ୍ସୁ ଲେଖି ଜଣାଇବାର ଏହିକି ଯେ ଆମ ଗ୍ରାମର ଶ୍ରୀ ମୁକୁନ୍ଦ ଜାନି ଗତ 4-5 ମାସ ତଳେ ମୋ ଝିଅ ଦେବକୀ ଜାନି ଓ ମୁକୁନ୍ଦ ଜାନି ଉଭୟ ସ୍ୱ ଇଚ୍ଛାରେ ଉଦଲିଆ ଯାଇଥିଲେ, କିନ୍ତୁ ଗତ କିଛି ଦିନ ହେଲା ମୋ ଜୁଇଁ ମୁକୁନ୍ଦ ଜାନି ମୋ ଝିଅ ଦେବକୀ ଜାନିକୁ ଟର୍ଚର କରୁଥିଲା, ଯାହା ଫଳରେ ମୋ ଝିଅ ଦେବକୀ ଜାନି ସେ ଆତ୍ମହତ୍ୟା କରିଛି।
But there is no allegation. Yes.
But there is, my lord, I may read the relevant portion of one statement of one of neighbor, my lord. ମୁଁ ଅମୁକ ଦେବକୀ ଜାନି ଆମ ଗାଁର ମୁକୁନ୍ଦ ଜାନି ନାମର ପିଲାକୁ ଭଲ ପାଇ ପ୍ରେମ ବିବାହ କରିଥିଲେ। ଆଜି 5 ମାସ ହେବ ମୁକୁନ୍ଦ ଘରେ ମୁକୁନ୍ଦର ସ୍ତ୍ରୀ ଭାବରେ ରହି ଆସୁଥିଲା। ମୁଁ ମଝିରେ ଶୁଣିବାକୁ ପାଇଥିଲି ଯେ ମୁକୁନ୍ଦ ଜାନି ଦେବକୀ ଜାନିକୁ ଶାରୀରିକ ଓ ମାନସିକ ନିର୍ଯାତନା ଦେଇଥିଲେ।
ଶୁଣିବାକୁ ପାଇଥିଲି।
ଆଜ୍ଞା। ଏବଂ ସେମାନଙ୍କ ସମ୍ପର୍କ ମଧ୍ୟ ଭଲ ନଥିଲା ବୋଲି।
ଶୁଣିବାକୁ ପାଇଥିଲି, here say. Here is not.
10-30 ତାରିଖ ଦିନ
That is the independent witness.
my lord, neighbor and independent witnesses. ଦେବକୀ ଜାନି ତାର ଓଢଣୀରେ ବେକରେ ବାନ୍ଧି ଫାଶୀ ଆତ୍ମହତ୍ୟା କରିଛି ବୋଲି ଏବଂ ଖବର ଶୁଣିବା ପରେ ମୋତେ ଟଙ୍କଧର
He has heard everything.
he may
What
have.
father says. See, it is Udilia marriage. That's what he says.
Another submit.
Devonjani, Mukunjani, where?
My lord, page number 16 is the 161 statement of the
It's
informant.
already there. Charge sheet has been filed.
Yes, ma'am.
Yes, my lord.
Charge sheet file 30/12.
Petitioner is accused in the FIR number. Let me comfort the petitioner submits that he has not filed any other petition which is pending. Petition regarding his bail plea, which is pending in any other court. The allegation against the petitioner is that the father of the victim has filed the FIR, entirely alleging that his daughter and the petitioners had married they were in love and they married. Due to the consistent torture meted out to his daughter, the daughter has committed suicide. In the allegation, there is nothing detail has been given. No overtake has been attributed to the petitioner, and the investigation is completed and charge sheet has been filed on. Filed on 30/12/2023. The petitioner is the petitioner has been charge sheeted for offence under section 498 capital A and 306 IP. He is in custody since 1/11/2023. Taking into consideration the regard being had to the period of custody and the nature of allegation made against the petitioner, and the fact that it is charge sheet has been filed, I am inclined to enlarge the petition on bail. Yes, next.
Oblige, Lord.
15.
Allot 20B to C, 4 packets inside the Swift Desire vehicle, and I was driving the vehicle.
How much?
60 kg, 15 into 4.
Your custody
Since, my lord, that I am in custody since 27/2023, more than 1 year I am in custody. 2023.
60 kilo.
60 kilo.
Yes. वो कर देना फॉर्मेट का मैं कर दूंगा।
Oblige, Lord.
Petitioner is accused in front of allegation against the petitioner is filed, and he is in custody since 27/7/2023. Charge sheet has already been filed. ठीक है? Next.
Petitioner in the custody since 10/10/2000.
60 kilo कितना? How much you said? 60 kilo? 60 kilo. Only 60. 60 kilo. Contraband 60 kilo. Yes.
Petitioner is in the custody since 10/10/2023, my lord. 10/10/2023, my lord.
Yes.
Allegations under section 363, 366, 342, 370. 60. 376 2N, 376.
My lord, may I bring one thing? May I bring one thing? My lord, CD is available.
Hmm.
One statement is also available. But what happened, my lord? In last order, my friend has also sent the letter, my lord.
Hmm.
But issue notice regarding the notice, my lord, because the six POCSO Act is there,
Yes.
age only 14 years. my lord.
That's 73 also
Again,
there.
376, 3. So notice has to go, my
Even
lord.
he is
one
not
of the
impleted.
informant has appeared.
No, no.
Already.
Have you impleted?
Yes, madam.
Impleted. You have not impleted.
Madam?
You have not impleted.
Informant, last occasion informant has appeared, my lord. His name is there, my lord.
So,
Sibo,
No, no. There is no one.
appear kar di.
No, there is no one. Last date.
Power is there, my name is there, my lord.
Power. Where is the power? Let us see.
year nine, so
Name,
Power.
some Rai, SS Rai, Siddharth Sankar Rai too, is the counsel for the informant. His name is, my lord, in this case, what happened?
Let us, my lord. Your lordship may.
Indra Das.
Yes, my
What
lord.
is the name?
Name, is Borsa Das.
Borsa?
Das.
SS Rai has filed.
Yes, my
Yes,
lord. Yes, my lord.
He has appeared, man.
But the name is Kongura Das. Yeah, Kongura Das.
Aadhaar name is Borsa, nickname is there.
What is the victim's name?
No, no, but victim may not be, my lord, utter in the court, my lord. But
No, no. Now I understand, but what is the name?
Name Borsa Das.
Father, my lord.
Father has given the program.
They is
Because
minor.
he is minor. He is
Minor.
minor. Okay.
Madam, kindly have a glance on the page 26, madam. The 16 word text.
Where is that? Where is
He is not here, madam.
Pass it over. Let us. Yes.
He is not here. madam.
Let him come. Yes.
17.
May I please, Your Lordship? Sir, my lord, the petitioner is inside the custody, my lord, since 15/9/2023, my lord.
My lord, I'm sorry to mention, my lord.
Yes.
CD is required, my lord. CD
CD.
is not.
CD.
CD has called for-
Waiting CD. Adjunct. Yes.
Your
Next.
Item number 17.
17.
CD. Next. 18.
Your Lordship, since March, CD has called for, my lord.
1 week time. Now regime has changed, you know. Yes.
March to
Yes.
July, August.
Next. 18.
Here, my lord, the present person is inside custody since, my lord, 14/10/2023, my lord. And the offense under section initially registered under section 302 of IPC.
1410.
My lord, 14/10/2023, my lord. My lord, now charges submitted under section 302, 212, 201, 34 of IPC, my lord. So far, the present prisoner is concerned, my lord, only allegation that he gave shelter to the
CD is there. CD is there.
Yes, my lord. CD is there and the real fact is, my lord, this petitioner was arrested only for to the main petitioner, my lord.
Show me.
Yes, my lord.
Yes. Show me the charges. He's not participated in the
No, my lord.
assault.
Certified copy.
Show me.
I am
You are in custody since
14
14/10/2023.
my lord. Only he gave shelter, my lord.
Which part?
Well, I have tick mark.
Which part?
In the middle, I have tick mark, my lord.
The accused Satya Deoria.
My lord.
So Uncle had harbored the accused Vinod Guru and to whom he had murdered
Under the honorable
with the
case, my lord.
intention of screening him from the legal punishment. Right. How they have killed?
Well, here, my allegation that one Vinodari suspected that the disease might have come.
Okay, right now. A petition will be accused in a fire number 4. Then account for the petition submits that no other bail application is pending. The allegation in the fire is take it over. After investigation has been filed on 9/2/2020. In the charge sheet, it has come that although the petitioner, the present petitioner, has not participated in the commission of the main crime. However, after the commission of the crime, he has given shelter to the principal accused. Principal accused being a friend.
Yes, my relative, my lord.
Being a relative. Being a relative. The charge in the charge sheet, it is the police has alleged in the charge sheet that the present accused had harbored the accused Vinod Guru, to whom he had knew to be the murderer with the intention of screening him from legal punishment. Hence, the present accused was arrested on 14/10/2020
Both the accused.
on the charges of harboring the accused Vinod Guru and
Prasad.
all the three accused persons. All the three accused persons. Since the petitioner is in custody, next one, since the petitioner is in custody on 14/10/2023 and charge sheet has already been filed on 9/2/2024. And the fact that the petitioner has not participated in the crime, he has been roped in the present case. He has harbored the principal accused in the instant case, so he is entitled to be released on bail with the condition that he shall not interfere with he shall not influence the witnesses, he will not contact the informant or any other eyewitnesses in any manner whatsoever. Whatsoever in the instant any found to we have contacted any witness in the present case in any manner whatsoever or in any further crime, the concession have been granted to him as shall be recorded, and the prosecution is given liberty to move applications for the trial court for recalling of the concession of bail in the event of violation of the bail condition.
Oblige.
Yes.
19.
Lordship, item 19, and you taken up one week after.
At Jan, September. Yes.
Item 20.
September. Your time is September.
The petitioner is in custody since 22/9/2023.
22/9/2023.
My lord, 302 matters, CD is required, my lord.
Your lordships, there are three matters actually. Maybe it is in other two briefs. I'm giving the numbers. There
This is one.
It's one matter. There in total 3 bail applications has been filed. Probably it is in another 2 matters. So let him verify that it will.
I didn't follow. 3. Why for one accused? 3?
No, your lordships, not 3. They are about 5 or 6
saying that
persons.
3 accused.
So separate bail applications. So probably it has been embedded to another bail application. So
So give the numbers. All the matters will be taken up today.
lordships, the number is 2106.
Give in writing. So
Lordships.
Tag with this
Again.
these matter
Lordships.
and call for CD. Okay.
Oblige.
In one matter CD comes then.
Yes, your lordships.
Next.
21.
May I please, your
Yes,
charge sheet submitted, my lord, 354A, 376 by 511 by 38 POCSO Act, my lord.
My lord, 21.
376 by-
That noting is that.
No, I have already solved the copy, my lord.
Would not
Your lordship.
Would not be served.
Due to late
Nobody-
filing of requisite.
No.
That
No,
way we have.
Both ways, court has stated both ways, my lord. I have
Service
solved
level-
one
service-
copy, my lord.
1 minute service. Position. There is nobody is complaining against you. Why are you getting hyper?
No, hyper 376 by 511. I have given shelter, my lord. I am in custody. Your lordship kindly certified copy.
373 is there. Let the informant be appeared, my lord. Informant will be victim.
Your lordship
He has
kindly
not
see the
participated in that.
164 statement, my lord.
No, charge sheet.
Charge sheet, my lord.
Your charge for 376 or what?
511, my lord.
Only
I have
511.
told- Yes, my lord.
My lord, this is mandatory that if 373 is there.
But if the charge is not 376, charge sheet is not filed in 376, then no mandatory.
My
It
lord,
is
charge
three.
sheet is-
He says only 311.
No, my lord, charge sheet under section
Let us see,
373
let us
there.
76, 511, my lord. Only attempt.
Where is that?
I have given, my lord.
Your
As
name,
sole
Santosh
accused, my
Kumar
lord.
Das, my lord.
your name is Santosh.
He is the sole accused. 376 by 511.
Sole accused, then service is required.
164, your lordship kindly peruse.
Service is required. Service, क्या position है?
Notice could not be issued.
Wow.
Non-filing of requisites.
Due to late filing of requisite.
Your lordship directed both ways, my lord. I
Do
was
it. Why are you unnecessary? This is the mandatory requirement under law.
No, I have given in postal, my lord, another given to state for compliance, my lord.
Is it necessary that we should waste time on this?
A short date may be fixed.
No, that's right.
Your lordship, fix
See
a
the
date.
pressure in the bench, we shouldn't waste and all this thing. You take necessary steps, sir.
One technical point is there, my lord. One technical point, my lord. Notice need not be required if the court, honorable court going to reject the prayer for bail.
He wants that it should be. That's
How?
he is giving a good idea.
Idea se idea ta kis din pore seita apply hoga.
But provided further that the High
Change
Court
the side, then the idea.
Mr. Savit,
Fix a date, my lord.
Yes, he'll fix. In all the
Your lordship, yesterday what happened, my lord? Since January I have filed the application. CD has not come. Your lordship directed to 13. I have seen that it is keep it to 30th, my lord.
We'll see.
That's why, my lord.
Yesterday is better. Today, let us come out of the problem of today. We'll see yesterday's thing.
A short date may be given, my lord.
Give a date because I am also traveling.
ନା ମୁଁ ଆଜ୍ଞା ତାକୁ 13 କହି ଦେଇଥିଲି ଦେଖିଲା ବେଳକୁ order 30th
Sometimes happens you know how to handle the clients.
My lord, your lordship decided that requisite may be issued.
Requisites may be accepted and
That may be-
notice may be issued.
Requisites may be accepted. The requisite already filed by the petitioner shall be utilized for the purpose of issuing fresh
Issuing.
notice.
Fix a short date.
Fix a date. Okay. Yeah.
May I please?
Yeah, 22 years.
My lord, the case is under section 376 clause 2 clause N minor 294 506 452 of the Indian Penal Code section 6 POCSO, my lord.
Yes.
And the FIR is, my lord, page number 9. May I place your lordship?
Yes, yes.
ଏତଲା ଗତ 23/10/2023 ତାରିଖ ଦିନ ମୋର ବାପା ଏବଂ ମା ଘରେ ନଥିଲେ। ମୁଁ ଏକାକୀ ଘରେ ଥିଲି। ରାତ୍ର ପ୍ରାୟ 10 ଘଣ୍ଟା ବେଳେ ମୁଁ ଘରେ ଥିଲା। ଏହି ସମୟରେ ଆମ ଗ୍ରାମର ଧୀରେନ ହରିଜନ ପିତା ସୋ ଜବରଦସ୍ତ ଆମ ଘର ଭିତରେ ପଶି ମୋର ଅନିଚ୍ଛା ସତ୍ତ୍ୱେ ମୋତେ ଧର୍ଷଣ କଲା। ଏହାପରେ ମୁଁ କାନ୍ଦିବାକୁ ଲାଗିଲି। ପରେ ସାହି ପଡ଼ିଶାର ଲୋକମାନେ ଆମ ଘରେ ରୁଣ୍ଡ ହେଲା ଲୋକମାନଙ୍କୁ ଦେଖି ଧୀରେନ ହରିଜନ ମୋତେ ସ୍ତ୍ରୀ କରିବାକୁ ରାଜି ହେଲା। କିଛି ସମୟ ପରେ ଧୀରେନ ହରିଜନ ତା ବାପା ଗୋବିନ୍ଦ ହରିଜନ ମା ନଇବି ହରିଜନ ମାନେ ଆମ ଘରୁ ମୋତେ ଗତ 24/10/2023 ତାରିଖ ସକାଳ ପ୍ରାୟ 7 ଘଣ୍ଟା ବେଳେ ତାଙ୍କ ଘରେ ନେଇଗଲେ। 3 ଦିନ ସେଠାରେ ମୋ ସହ ରହି ଧୀରେନ ହରିଜନ କେଉଁଆଡ଼େ ଚାଲିଗଲା। ମୁଁ ବାରମ୍ବାର ଫୋନ କଲି। ଧୀରେନ ହରିଜନ ମୋତେ ସୋ ଆଣ୍ଡ ସୋ ଗାଳି
What is the stage?
ମାନେ ଚାର୍ଜ ସିଟ୍ ସବମିଟେଡ୍ ମାନେ
Charge sheet submitted.
Wait.
On 11/1/2024.
Wait, because in this case it's the reverse thing. It is not love and thereafter sexual intercourse. But first you had sexual intercourse. Thereafter, when the people got hold of you, then you say that yes, reversal this thing.
And
So
my lord,
therefore, victim has to be examined.
next date
Victim.
I will take instruction whether victim examined or not.
Then I'll say that the petitioner is agreed by the order dated. A petitioner is accused of
6/1/2020.
by 6/1/2024, whereby his bail plea has been rejected. The allegation, the statement, I have perused the statement for the victim under section 164 CRBC. I am not inclined to grant the petitioner, admit the petitioner on bail at this stage. However, liberty is granted to the petitioner to renew his bail plea after the victim is examined in the instant case. Instant. With this liberty, this petition is disposed. Next. Yes, sir.
Your lordship, in item 22, our names may be deleted. The brief has been transferred. My friend is appearing in this case.
I have deleted the petition itself. Why do you worry about your name?
Grateful, Lord.
Yes.
May I please, Your Honor? My lord, this is a case under section 302, 364, 34 IPC. My lord, in total, there are 6 number of accused in this case, and I am for Sujam Bhavasagar. My lord, the allegation against me is only under section 364, my lord. My lord, on 30th November 2023, one unknown dead body was recovered, for which The Baghiapada outpost police in
CDS, no, CD available.
one unknown dead body was recovered on 30 November 2023, for which the in charge of Baghiapada outpost has submitted one FIR, and subsequently, my lord, on 6th December 2023, one knife was recovered under Section 27 Evidence Act, being identified by one co-accused Mahendra Bhabasagar, wherein he has confessed that he has killed the deceased and with the help of other accused persons, my lord.
Yes.
Only allegation against me is under Section 364, my lord. My lord, further, I would like to identify in this case that there is the prosecution itself is contradictory in this case, my lord. As per the FIR, the dead body was recovered on 30th November 2023, whereas in the 161 statement, two witnesses have clearly stated that on 6th December 2023, they have seen the accused person kill the deceased, Your Honor, which is a completely contradictory.
Sorry, you give me the deadline.
My lord, on 30th recovery dead body was recovered on 30th 11 2023, whereas two prosecution witnesses have clearly stated that on 6th December 2023, they have seen the accused person kill the deceased after 6 days of recovery of dead body, my lord. And those two witnesses are also witness to the Section 27 Evidence Act and also the witness to the recovery of weapon and other biological materials.
You are in custody since?
I am in
6/12/23.
6/12/2023. My lord, I am a college student. And all the whole family is.
What is this? If the witnesses in 164 statement, they say that they've seen the incident on 6/12/2023, whereas the dead body appears to have recovered on 30th September, about 6 days.
My lord, nobody has seen. This is a totally unknown affair.
Yes,
and the
but
specific role of the present.
Show me the evidence of these two witnesses. Who all are the witnesses?
Those are, Your Honor, my lord, those are Ratnakar Mahanandia and Dondua Podo. Ratnakar Mahanandia and Dondua Podo.
Ratnakar Mahanandia and the same witnesses are the witness to the 27. Is that so?
My lord, Ratnakar is the one of the seizure witness, man.
Oh, that's right. Seizure means 27. What is he saying regarding the incident? Has he seen?
No, no one has seen, my lord. His present petitioner role is that, my lord, on the basis of confessional statement of one of the accused, Mahendra Bhagavar, he has stated that Mahendra Bhagavan himself and this present petitioner, other accused persons, they have killed. And the specific role of the present petitioner is that, my lord, that the vehicle which was used in the crime, that belongs to the present petitioner. And there was a reason is, my lord, that there is black magic. The reason behind that murder is black magic. And one of the minor son of the deceased, his statement shows that there was prior enmity because his deceased father has told that have enmity with the accused persons. I'm reading that portion, my lord, to find out that whether there is any dispute or not.
No, the facts are not important. Important is what are the evidence against him.
Evidence only two. That is his car is used.
Confessional statement of one of the accused.
And another one is extrajudicial confession of one of the accused from whom recovery of that knife was seized. Only that.
That is the same accused.
Car was used, my lord. First thing is the vehicle was used.
The car is
belongs to present petitioner. And the confessional statement of one of the accused from whom knife was seized, leading to discover knife was seized. He has stated that myself and this present petitioner, other accused persons, they have killed.
Charge is in frame?
My lord, charge framed on 2/3/24.
2/3/24.
Under section 302, 364 and 120B, my lord.
Against all of them?
Against all of them.
My lord, in the
material witness?
My lord, one, my lord, the minor son, my lord, that of the deceased. My lord, more that is, I'm submitting, my lord, that is prior dispute is there, my lord. That
no, the prior dispute motive you are bringing. Motive against this accused or the other accused?
This accused, man. That relevant person. More Bapa Hore Koutre, Mahendra Bhavsagar, Ashok Kohara, Pramod, Shubham Bhavsagar, Sanjeev, Surjam is the my lord present petitioner. Surjam, Bhavsagar or Sanjeev ଜୀବନରୁ ମାରିଦେବାକୁ କହିଛନ୍ତି କାରଣ ତାଙ୍କର ଅନୁମାନ ଯେ ଶୁଭମର ବାପା ମହେନ୍ଦ୍ର ବାପାକୁ ଗୁଣି ଗାରେଡି କରି ମାରି ଦେଇଛନ୍ତି। And another one is Sudhanshu Kumar, before whom the co-accused has given confessional statement, my lord. No, that is extrajudicial confession. Or his 164 statement also recorded, my lord.
164 is recorded.
My lord, 164.
Who is that witness?
That is my lord.
How many witnesses? 164 you have. How many witnesses? 164 you have.
2 witnesses. One is my lord.
Then yes, Mr. Mishra, you have to wait till the material witnesses are examined.
My lord, in the meanwhile, 2 witnesses have already been examined. Those are which I are talking about. Those are section 27 witnesses, my lord. And though both of them has turned hostile, my lord.
When they were examined?
Yesterday only they have been examined, and both of them have turned yesterday, my lord.
Yesterday.
And I would like to point out one, my lord. I would like to point out one very material defect in this case, my lord. My lord,
Then do one thing. Do one thing. Your application is rejected on
31/24
January 2024.
My lord.
And thereafter material witnesses have already been examined and they did not support the case. Then you must go to the court of first instance and tell that. Thereafter you come. I will record that.
My lord, one thing I would like to submit before this honorable court, my lord, without referring to the witnesses also, there is one very material defect in the case of prosecution, my lord. One hand, they are saying that the occurrence took place, that the dead body was recovered on 30th of November, whereas their witnesses are only stating that they have seen the deceased being killed on 6th of December.
That's what I asked, but where is that? You have not, you are not showing me.
My lord, I would like to, with the permission of, my lord, I would like to screen share the 161 statement.
Where is that?
Ratnakar Mahanandya, my lord, he has stated that ମୋର ନାମ ରତ୍ନାକର ମହାନନ୍ଦିଆ ଆଜି ତା 6/12/2023 ରିଖ ଦିନ ଆପଣଙ୍କ ଠାରେ ମୋର ମୌଖିକ ବୟାନ ଏହିକି ଯେ ଆଜି ଭୋର 5:30 ସମୟରେ ତିଲପଙ୍ଗା ଗ୍ରାମର ମହେନ୍ଦ୍ର ଭବସାଗର ରାଜେନ୍ଦ୍ର ଭବସାଗର and other accused persons ମିଶି ଗ୍ରାମର ମଧୁ କହରକୁ ଏକ କାରରେ ଯାହାର ନମ୍ବର ସୋ ଏଣ୍ଡ ସୋ ଅପହରଣ କରି ସେହି କାରରେ ପଛେ ପଛେ ଏକ ବାଇକ ରେ ଯାହାର ନମ୍ବର ସୋ ଏଣ୍ଡ ସୋ ଗଲେ।
The witnesses are saying Aji.
Well, the witness itself are contradicting, my lord, without referring to
23, but
recovery, body recovery and 30th. And on 60, the witness says that Aji dhari gole mu dekhili.
That was written in 161. There may be some contradiction in the.
That
will be decided.
One minute. Whether this witness has already been examined by the trial court?
These two witnesses have been examined and turned hostile, my lord.
Then it goes against you.
The prosecution case itself is contradictory.
Yes,
And
the witnesses, those who supported you in 161, has gone hostile, then it goes against you.
My lord, from the very beginning of the case, the prosecution case itself is contradictory, my lord.
What are these two witnesses? 164 statements recorded has not been examined, it seems.
My lord.
Tell me the name of the two witnesses.
One is the wife of the deceased.
Wife of the deceased, and
namely Sadai Kaur.
Sadai.
My lord. Another one is Kaur, my lord. Sadan Kaur.
Who is he?
My lord, before whom that extrajudicial confession was made.
Right. The petitioner is agreed by the order dated 30/2024, whereby the bail plea of the petitioners has been rejected. Mr.
My lord, before any order is passed, I would like to submit one more thing, my lord. My lord, in this case, there is no allegation against me under section 302. Only allegation is under section 364, my lord.
I am recording those things. I'm giving you. You are arguing very good. Therefore, I am entertaining you. Otherwise, I would have. Anyway, I'll record it. All these things right now. The petitioner contended that the allegation as per the allegation of the prosecution, only 364 is made out.
Only 364.
364 is made out. No allegation about 302 is alleged against him. he further submits that two witnesses have very categorically stated in their 161 statement that they had seen the deceased in the company of the accused persons on 6/12/2023, whereas the prosecution case is the dead body of the deceased was recovered on 30th of November 2023. November 23. November 23. Therefore, the false implication in the present case is not ruled out. The counsel for the state submits that there are two witnesses, namely the wife of the deceased and one independent witness, Saddam. Before whom the extrajudicial confession has been made, are already examined by the police under section 164, and already given their statement under 164 CRPC. And these witnesses are to be examined by the court. Mr. Mishra, and counsel for the petitioner, submits that yesterday two material witnesses have been examined with the trial court, those who have not supported the prosecution. Since the bail application has been rejected by the trial court on 30th January 2024, and much has taken place in the trial is in Karachi, and much has been the trial has proceeded substantially. But it would be appropriate that the petitioners to approach the trial court, approach the court of first instance, reviewing his bail application. If the petitioner moves such bail application, the trial court shall consider the same on its own merit, and petitioner has the liberty to raise all these points before the trial court. With this observation, the petition is disposed of. Yes.
24.
Yes. I have recorded everything, Mr. Mishra. You will get handle there to argue. Yes. I'll just come. Okay.
Again, 2I506.
Yes.
Victim is aged about 45 years, my lord.
Victim,
my lord.
yes.
On date of incident is 16/11/2023. The FIR was registered on 21/11/2023.
What are the allegation? Let us see.
Allegation, my lord, so far allegation is concerned, my lord. The victim along with the petitioner, they went in a motorcycle to collect his bhatta. On the way, my lord, the petitioner, without going to the GP, my lord, to collect his bhatta, my lord, went to a nearby temple where he has allegation that he has committed rape on her. They went to the GP and collected his fees, my lord.
After the rape,
my lord.
My lord, she is a physical handicapped lady.
She is a ମାନେ ସେ କାଇଁ ଖନେଇ କହୁଛି ସେ physical handicap
let him complete the
My lord.
sentence. At least
all the evidence, my
he
lord.
started a sentence. Let him complete.
My lord, she is physical
I'm
ଧରୁଛନ୍ତି.
reading the-
What are the allegations?
And I am reading the 164 statement of that.
Read it.
My name is so and so. ଏଇକି ଯେ ଗତ 16/11/23 ତାରିଖ ଗାଇସିଲଟ ଭତ୍ତା ଆଣିବା ପାଇଁ ଯାଇଥିଲି ଆମ ଗାଁର ପରମାନନ୍ଦ ପ୍ରଧାନ ଦ୍ୟାଟ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର
Yes.
ଫଟଫଟିରେ ଯାଉଥିଲେ ମୁଁ ତାକୁ ମତେ ନେଇଯିବା ପାଇଁ କହିଲି ତା ସାଙ୍ଗେ ମୁଁ ଶିବ ମନ୍ଦିର ପାଶେ ଥିବା ଏକ ଜଙ୍ଗଲକେ ନେଇକରି ଗଲା ସେ ସେଠାରେ ମତେ
summary while speaking. Land counsel for the petitioner has taken me to the medical evidence. The incident has taken place on 21/11/2023, and on the very next day, the medical examination after the who is 45 years old, has taken place. The doctor has applied that on general evaluation, no bodily injury was found, suggesting penetrating sexual assault. No recent full stop. No recent sign of sign and symptom is found. Sign and symptom of any sexual assault was found. No. On genital examination, no recent sign and symptom of any sexual assault is found. The medical, the 164 statement, if the 164 statement and the medical evidence is taken into consideration, it seems there is a variation in the prosecution story. Therefore, the petition is entitled to grant of bail. Petitioner is in custody 11/20/23. Regarding head to the allegation, regarding head to the custody period and allegation made also, and with the condition that the petitioner shall not contact in any manner whatsoever with the victim till her deposition before the trial court is over. Okay.
Obliged.
Yes, next.
25.
Yes.
With leave of your lordship, my lord. The case under section 20 of NDPS Act, section
Recovery?
20B.
1038 kg.
A ton of ganja, but he was arrested since 13th of October 2019. 13 of October 2019. He is in custody.
Yes.
Charge sheet has been submitted on 31st of October 2020. Out of 42 witnesses, only 8 witnesses in the meantime have been examined. Out of them, my lords, none of them has stated anything against the petitioner.
How many accused are there in this case?
Only person. madam.
Only person. They say
1038 kg from the Hawa truck.
I'm a driver, as a truck, they say that all these things will happen.
Whatever.
And to persuade your lordships, if I am permitted, I can place one.
No.
Order of your
1,000 I will not give it. 1,000 unnecessary weight. And
Yes,
I can only expect that the trial should expedite.
well, that will also oblige me.
Matters, so trial should be.
Yes.
2000, when the FIR?
That is of 2019.
Right on. The petitioner is.
Since, may I
the
submit?
petitioner is, yes.
Subject to your lordship's
Yes,
approval.
yes.
Since I have a ton of ganja, I need not press further. But only for your lordship's observation, consideration, may I place only
You advise
one.
your client to do it in installment basis instead of carrying so much at a time.
That I will advise not to do it again. And there is no criminal antecedents. But it's a matter of 3 quintals
Criminal,
also.
if you do installmentally, then there would be criminal.
Might be.
In one go, if you want to take everything.
You probably wanted to, naturally the driver might not have.
How much time will you take to conclude the trial? See, what happens is, irrespective of the quantity,
Yes.
invariably the cases end up in acquittal.
Yes. And in one of such cases, I'm just placing a
The trial
judgment.
period is the only period that is the penalty for them.
In our Odisha case, Honorable Supreme Court has observed identically as your lordship just now observes, that is 3 quintal.
Quality of evidence is so bad.
Yes.
For prosecution.
Your lordship sees.
And you will see in many cases, it is a copy paste charge sheet.
Yes.
Only they'll change the quantity and the names and file it.
Your lordship
That is
sees.
the reason it is ended up in.
Yes. Your lordship sees paragraph 3 and 4 and 5. A very small. And there they have, their lordships have been pleased to distinguish what is section 37 of the NDPS Act. Out of 19 witnesses, 1 witness, 3 quintals in a truck. They say it is 3 years in custody. There has been no inch of progress of the investigation. Hence, their lordships have been pleased to.
I will give you 6 months. Within 6 months, if they don't complete and you.
I will approach your lordships again. I'm grateful, madam.
That's the better idea.
Yes, madam. Always.
2019, he is in the custody.
Yes, madam. Almost 5 years.
5 years. So 6 months, you complete, right on. The petitioner is agreed by the dated 4/11/2023, whereby his bail plea has been rejected. He is an accused in FIR number so and so, wherein the allegation is the 1000, how much? 1000?
1038.5.
532 gram.
1038
kg.
38 kg, 32
532 gram.
Contraband ganja is recovered from his possession. The petitioner is in custody since 13/10/2019. It is informed the prosecution for the state submits that out of how many witnesses?
Out of 42,
Out of 42 witnesses,
8
only
have been.
8 witnesses.
Yes, have been good.
Since the petitioner is
Taken into
already in
account.
the custody about 3.5 years, 3.5, 4.5.
4.5, more than 4.5.
4.5 years. It's expected that the trial court should do well to see that the trial is concluded as expeditiously as possible. Owing to the fact that the recovery is huge, and I'm not inclined to admit bail. However, liberty is granted to the petitioner to renew his bail application after expiry of 6 months if the trial is not progressing in the expected pace. With this observation,
With the supply of the deposit of that certified copy of the order. Subject to deposit of that certified copy of the order. But how could the court?
Yes, they don't do
Yes,
it. Right on. The petitioner is directed to the copy of this order may be communicated to the trial court. Yes.
And liberty has been granted to me,
Liberty
man.
is granted.
Renew my prayer.
Copy will go to trial court.
Yeah. And renew my prayer after,
After
6 months.
That I have taken.
Grateful.
Yes. It's 6. And it is further made clear that the petitioner shall not seek adjournment before the trial court on any pretext.
True. Yes.
Not that 6 months you keep on asking for adjournment.
Yes, yes.
Yes.
Grateful.
26. Yeah, please, your lords.
Yes.
Let alleged offense under section 376 2 and I. And so the FIR was registered under section 342, 376 2 and I. The charge sheet was submitted only under section 376 2 and I. I'm in custody.
11/11/23.
My lord.
11/11/23.
11/11/2023.
Yes. Show me the allegation. 164.
64
running
and
page
victim is
70.
a defend of garbage.
That is in the running page 17, the 164 statement. See the 27-year lady, my lord, girl.
Defendant.
Yeah.
Defender.
That statement is there. It appears that there was a.
Has been examined by the court.
No, my lord.
That
She has not examined.
Wait, defendant girl 376.
And my lord, medical exam.
Otherwise, I read 164 and grant the bail.
That is only medical
defendant,
medical examination. That is your lordship. That I don't want to.
Medical maybe whatever.
There is sign made. Both that the present petition, there is medical exemption report. Both the petitioner has signed, my lord, and the victim has also signed.
No, injury, there is no injury.
Injury.
That is your lordship, my direct. Case is my lord, posted my lord 12th.
Petitioner is agreed by the order dated, where is that order? Order dated,
Order matter that is 6/2/2024.
He's accusing so by that. 6/2/2024, whereby his bail plea has been rejected. I have perused the records and found that the state found that there are allegations against the petitioner, and the victim appears to be a deaf and dumb girl. Therefore, I am not inclined to grant the admit the petitioner on bail until the victim is examined by the court. Examined by the court. Petitioner is given liberty. The petitioner is disposed of at this stage with the liberty to the petitioner to revive his bail plea before the trial court, before the court of first instance, after the examination of the victim. Yes. 27.
48 kg, my lord. No criminal antecedent. 48 kg.
Custody since
9/2/2024.
9/2/2024.
2 and charge sheet submitted, my lord, 23/7/2024.
23.
7/2024.
Yes.
And no criminal antecedent.
My lord, sir, from UP, my lord. This person
My
from
lord.
UP. And contraband
Antecedent.
ganja was though less, my lord, 48 kg. But it's outsider.
Fortunately, he's a citizen. What to do?
That is correct, my lord. He may assure that he will appear before the court below.
What condition you in the outsiders? We can't distinguish outsiders.
And that is correct.
But the
because-
harsh reality is once
Yes.
they get bail, they don't come. That's the harsh reality.
Only that.
But how to strike a balance between these two? It is the prosecution who has to suggest. How will you secure their presence?
And if local security will be there, because if they will not come, then it will be that security will be go to the.
The problem I have
Adalat
seen
and
the
further
I have
insurance.
seen the instances where 5 lakhs cash security they furnish and plead away.
Well, it was happened, madam. In another.
Huh.
In another court.
5 lakhs.
Yes, madam. In another court.
What
that,
the security couple of thousand, they don't bother about it.
Yes, yes, madam. In another court that cost was imposed, madam. 5 lakhs is what they played out.
And the local security will come and say that okay, 40, 50,000, 30,000 I'll deposit. What to
And
do?
my lord, it will be deposit, it will be decided in the local adalat. Subsequently, if they will
He is
not,
out.
it will be decided in the local adalat.
That's the whole difficulty. How to strike a balance? You have to evolve some idea. But you can't distinguish in the same time because he is outside, he will not get the bail. That's
Only,
another
my
issue.
lord, only predicament is
Local.
that his presence is required at the time. That is all.
ମିଲର ଆମ ଲୋକାଲ ମିଲର ଆଡ୍ରେସ ଫର୍ନିଶ କରିବୁ ଏବଂ ଲୋକାଲ ପୋଲିସ ଷ୍ଟେସନରେ ବି ଆପିୟର କରିବୁ ୱିଥ କଣ୍ଟାକ୍ଟ ନମ୍ବର ବି ମୋବାଇଲ ନମ୍ବର ଦେଇକି ଯିବୁ and that will be not changed if so urgent not required ମିଲର
No, which is your local police station?
That is Padua, my lord. Padua.
No, Padua.
No.
Padua in the district of Korak.
I know, but you are staying where?
Oh, he belongs to UP.
UP, which police?
ପୋଲିସ ହାତ୍ରାସ ମିଲର
Huh?
ହାତ୍ରାସ ମିଲର
Hatras. Do you have any mechanism to contact the local police of those areas? Suppose I give a direction that he should go to Hatras police station and appear every week and all. Do you have any mechanism to have a contact that whether he is appearing or not? Or anything?
At best, that the superintendent of police, he will write a letter to that district superintendent of police of UP. Whether the instruction will come or not, that will matter. That will be difficult. That he will inquire.
କଣ୍ଟାକ୍ଟ ନମ୍ବର ଫର୍ନିଶ କରିକି ଦେବୁ and
You for going out, you will do everything. That's
ଯାଇପାରିବୁ
the problem. After going out, what you do, that is more important. Now you will say,
No, Milord, in fact, if
now to
some persons
get
are
out of
fled away,
authority, you
that does not mean local, Milord, outsider not.
impossible thing also will say.
Milord, that does not mean outsiders are not facing trial here. Some persons are admittedly faced.
There are
fled out.
instances, therefore.
Yes, Milord, 1 to 5 instances are there, but 1 to 90 Milord persons are facing trial. They may get acquittal, everything. Milord. Because आजिकल में contact number रहुचे आसिके appear करी
Grant bail with an additional condition that the petitioner shall furnish a local and a surety and he surety relative.
relative family में PR bond रे no PR bond
relative, also a relative.
PR bond
Shall furnish a PR bond of a relative. And he shall also furnish the local address and local police station, head local police station. Petitioner, without fail, the petitioner should appear before the trial court on each and every date of hearing, and he shall report to the Hatras PS Hatras. He shall report to the SHO. Hatras PS, every fortnight, fortnight. The SP, the SP Koraput, Superintendent of Police Koraput shall obtain a report from the Hatras police station regarding the appearances to be made by the petitioner before that police station. Next one. If the petitioner is found to have indulged in any further crime or found not complying with the conditions of this condition of bail, imposed by this court, the petitioner, the prosecution is at liberty to move appropriate application before the court below for the seeking for cancellation of bail, for cancellation of bail. SP has to write a letter to the authorized police station regarding whether he is appearing or not fortnight.
Yes, yes.
If he is not appearing, and move an application and recall. And ये कर दो जो outside रह करके देखते हैं. Let us try.
Yes.
In couple of matters, what happens? Let us see. Yes. 28.
28 will not same.
Another co-accused.
Another co-accused. Same FIR.
Same.
Same
FIR.
FIR.
Recovery will लिख देना 48 kilos है.
But my lord, police station is different. That
Police
is
station differently.
Atroli in the district of Aligarh, Uttar Pradesh.
Amrohi. What is that?
Atroli.
What is that?
Phase 2 man. Atroli in the district of Aligarh or
Aligarh district. Atroli. Atroli. Yes.
Here, my lord.
Yes.
29. Custody 24/2023. And this is committed suicide, blotting the door inside the room. And my lord.
No. You talk about 29. 28, you are in custody since?
27, 28 same gola pa sidita.
Arre bhai, you tell me the custody period, sir. 27 you are in custody?
Same 9/2/2000.
9/2/2024.
20. Char sabu same.
Charge sheet filed on 23/7/2020.
Yes, sabu same.
Okay. Come to
29 my lord 304B
suicide
format. CD.
Committed suicide.
CD. Call for CD. Okay. Next.
Blotting the door inside the room.
CD. Blotting the door from inside.
Inside.
You'll let the CD
Custody, short dead.
Yes.
Interim bail was granted, but he not surrendered, man.
Not surrender.
He
You don't ask for interim bail then.
Baripodalo could there mainly
Dated which year?
first interim bail hitla 13/4/5/4/2024.
5/4/2024.
Again, it is extended on 8/5/2024
By
the
order
basis
dated
of the affidavit.
2024. The petitioner is accused on so, and he has approved this court challenging the order dated 19/2/2024 passed by the trial court rejecting his bail application. While the present petition was pending before this court on 5/4/2024. Interim bail was granted to him, and subsequently on 8/5/2024, again it was extended. It is the learned counsel for the petitioner submits that the petitioner has not surrendered as yet. In view of the same, the present petition is dismissed, and necessary prosecution the trial court should take necessary steps to ensure the presence of the petitioner.
ସକାଳେ ବି ମୁଁ ତା ସାଙ୍ଗେ କଥା ହେଲି କହୁଛି କୋର୍ଟ ଦେଲେ ବେଲ
What can you do? Can't do anything.
order be communicated.
Lordship. Charge sheet submitted.
31.
Yes, my lord. Custody since 15/11/23.
15/11/23.
Charge sheet submitted on 31/3/24, my lord. I have given the 164 statement, my lord. Certified copy of 160. I have annexed. I have given the certified copy, my lord.
Yes. Why are you appearing in all these kind of matters? All 376 matters. Yes.
The victim is 7 years, man. Victim is 7 years.
164, your lordship kindly see. Yes, ma'am. 64 statement, your lordship kindly peruse. No 376 is my doubt, my lord.
What 164 at 7 years girl?
ଆଜ୍ଞା ସେ ନିଜେ କହିଲା ଆଜ୍ଞା ମାଜିଷ୍ଟ୍ରେଟ ଆଗରେ
Read it.
ଆଜ୍ଞା
Why?
no medical report. medical report. Medical report, the three, no intercourse, my lord, nothing. And medical report is same, my lord.
7-year girl.
I guess 7 year out of
1 minute.
political dispute, my lord, these things happen, my
1
lord.
minute. 7-year girl will not tell a lie.
Again, say kotha 164 again, nothing has been
I
stated,
will
my
not
lord.
give 7-year girl, you are 38-year man and you
No,
are calling that
both
girl.
are neighbor, my lord. What happened, my lord? 376 is not made out, my lord.
Maybe. In the 38-year-old, you are 38-year-old.
30 years.
I am a ward member, my lord. Out of political dispute, this case happened, my lord. 7 years.
Eyewitness are there, my
No.
So,
Again,
witnesses are there.
statement.
Eyewitness who are.
Some minor child, my lord, they were the eyewitnesses.
The children will not speak lie.
No, again, siye to nije again kohuni kichi. On the same day, she is.
ଯେତିକି କହିଛି ସେତିକି କାଫି ଦେଖନ୍ତୁ ଆପଣ ପଢନ୍ତୁ
Aye, how 376 is made out, my lord?
Nice. I am not talking about girl. Don't expect 376. Don't expect 376 for a 7-year-old girl, and you are 38-year-old man. And
medical report, your lordship kindly peruse.
You have
Medical report, your lordship kindly peruse the medical report.
report. There won't be anything.
Yes, my lord. You will custody, my lord, since November, my lord. Your lordship, 10 months is in custody, my lord.
If these kind of cases are bail is granted, then the very purpose of POXO is defeated. I can understand.
Your lordship,
17-year, 18-year, they are in adolescent. They do something.
nothing is there. My lord, nothing is there, my lord.
This type of, my lord, offenses can.
No, my lord. Your lordship kindly peruse the case diary, my lord. Nothing happened, my lord.
Not inclined. Not inclined. Sorry. I can understand POXO. 17, 18-year-old girl.
Again,
and the boy is 26.
No, your lordship kindly visualize, my lord. Your lordship kindly visualize. Nothing has been stated. Medical report does not support the case, my lord. Otherwise,
What do you mean medical report for a 7-year girl?
He has not stated.
Ask him to nude and you got nuded. What was necessary to get nuded in front of the girl?
At best case of 354, my lord. 10 months is in custody.
Living POXO.
POXO at best, your lordship kindly see charge sheet 6 POXO Act.
Let the child examine.
Already examined, my lord. Child, 164 statement was recorded, my lord.
Report.
Deposition, yes.
Deposition. Write down. The petitioner is agreed by the order dated 29/1/2024. First petitioner is agreed. The victim girl is a 7-year-old child, and the petitioner is 38-year-old. 38-year-old. The allegation, I have perused the evidence, perused the statement recorded under 164 CRPC. I am not inclined to.
No, your lordship indicate that he has not stated about the 376 is concerned,
my lord. That observation will be made.
Why? That may be reflected, my lord.
I'm not inclined to grant admit the petitioner on bail in case. However, liberty is granted to petitioner to renew his bail application after the deposition, after the recording of evidence of the victim girl and the
other eyewitness matter.
Other eyewitnesses, they have not present, my lord. They have not stated anything, my lord. Your lordship indicate that what happened. What he has stated in 164, your lordship indicate that.
See, wherever bail is.
Your lordship rejected my application. I have no objection, my lord. Your lordship reflected that what in 164.
Whether you have objection or not, that's not an issue. Issue is, Mr. Sahu, wherever there is a possibility of bail, I'm giving. Not that I'm not giving. But these are the cases where very harsh.
Out of political dispute, my lord, this occurrence, this affair has been lost. Only to harass the. There is a.
I can understand is 161 statement. It's 164 statement recorded before magistrate. A small girl of 7 years, she was asked, and everything she is narrating all that.
At best case of 354, my lord. Your lordship indicate that what stated in the 164 and reject my application.
354, you tell me. Tell me in simple.
It may be 354 abone.
What is the offense of 354? When 354 takes place?
এটা
modesty of, you tell me.
ওমেন
Women. 7-year girl is a woman. What are you talking? Why are you unnecessary arguing? 354. How can you think?
509 হব নলে ଆଉ আজ্ঞା 376 কথা ଆଜ୍ଞା ଜମା
Thank you that you are improving your case. Revive your application after the victim is examined.
after tutor my lord she have stated before
I
the
don't know
after
tutor what, I don't know. If see the law is promulgated only to protect these kind of children.
now
Not
the
innocent.
compensation is there my lord now increasing day by day the cases my lord.
That's right, but what to do? What to do?
Lordship indicate that what stated before the 164 before the magistrate that may be indicate my
It
lord.
will prejudice you, I tell you. I'll write it. I have no issue. Prejudice. If the High Court writes something, observes something while rejecting, that will weigh in the mind of the trial court. And you may not get the bail. I'll record it if you say.
My lord, the 164 statement is very much available for the court bill.
Serious statement. You want
Why observation will be made?
You want that it should be reflected in the rejection order. I'll do it.
Yes my lord reflect.
I fill the child victim. In statement they are stated that the accused name. It said that address the child victim address accused his elder brother who appears to have called who appears who called her asked her to get nude and he himself get nude. When at that point in time, when the brother of the victim called, immediately she left the spot. Mrs. Howell and counsel for the petitioner, taking me to the medical evidence, submit that there is no sexual intercourse. There is no allegation of sexual intercourse. The medical evidence is also supporting this aspect of the matter. Therefore, he is
Not supporting though.
not seeking indemnity of this court on the ground that his client is in custody since 15/11/2023. I'm not inclined and
Yes.
yes.
Obligation.
May it please the Lordship.
Yes.
Lordship is a case of elopement, Lordship. Petitioner is in custody since 3/11/2022, Lordship.
Here in this case, I am appearing for the informant to be examined. Yes, that is the instruction today morning I have received, my lord. Only I have to be examined. Your lordship call for a report and dispose of.
Last,
Lordship. So 164, Lordship, she had consensually shared relationship.
What
with
about
her.
the other witnesses? Have they supported?
No, Lordship. Now only 5 have been examined out of 17.
Out of
Only the family members have been examined till date.
they have supported the prosecution.
Lordship.
Some extent. Then the only IO statement is to be recorded.
Lordship, because he's in custody since
Let her argue.
2022.
Let her argue. I know that IO, but she has studied then.
Yes,
let
my
her-
lord, your lordship
What
call
is
for a
your case
report
like?
and pass any order.
Let her argue.
Yes.
Yes. What is the case?
Lordship, the case is 363, 366
Are you
and
sure that you are entitled to bail?
Lordship, because already the petitioner was enlarged on bail, Lordship, by this honorable court. And a similar, 2 sorts of FIR were lodged, Lordship.
Oh, you are habitual.
Lordship. No, Lordship, one similar case, Lordship, for this.
But in that case,
Lordship,
trial
same,
was
same.
going on.
Yes, Lordship.
Victim has already been examined, na?
Lordship, as PW4, Lordship.
So, show me the victim's statement.
It's a page 17 of the brief.
17.
Lordship.
17.
17, Lordship.
Yes.
Lordship, may I be permitted to read?
Yes.
ମୁଁ 2 ବର୍ଷ ହେଲାଣି ଚନ୍ଦ୍ରକାନ୍ତ ରାଉତକୁ ଭଲ ପାଉଛି। ମୁଁ ପ୍ରଥମେ ମାର୍ଚ୍ଚ 2022 ରେ ତାଙ୍କ ସାଙ୍ଗରେ ଚେନ୍ନାଇ ପଳେଇଥିଲି। ମୋ ଘର ଲୋକ କେସ୍ କରିଥିଲେ ତ ଆମେ ଦିନ ଭିତରେ ଆସିଥିଲୁ। ତାପରେ ମୁଁ ଆମ ଘରେ ରହୁଥିଲି। ବାପା ଫୋନ ଦେଇ ନଥିଲେ କିନ୍ତୁ ମୁଁ ତାଙ୍କ ଠାରୁ ଲୁଚିକି 2-3 ଥର ଚନ୍ଦ୍ରକାନ୍ତ ରାଉତ କରିଥିଲି। ମୁଁ ମେ 2022 ରେ ତାକୁ କହିଲି କି କାଳେ ଘରେ ଲୋକ ଆମକୁ ବାହା କରେଇବେ ନାହିଁ। ବାପା ମତେ ସବୁଦିନ ଟ୍ୟୁସନ ନେବା ଆଣା କରୁଥିଲେ। 7 ମେ 2022 ରେ ବାପା କ ଦେହ ଭଲ ନଥିଲା ତ ମୁଁ ମତେ ଟ୍ୟୁସନ ଛାଡିବା ପାଇଁ ଗଲେ ନାହିଁ। ମୁଁ ତାଙ୍କ ଟ୍ୟୁସନ ପାଖରେ
What is the name of this? Oh, sorry, I will read it. Huh?
Lodge.
Okay, what about this case? Another girl.
Lordship, he was on bail, Lordship.
But that's right, another girl.
Yes,
Lordship.
that is
How
another.
many- how-
Same girl, Lordship. Lopamudra
How
Samantha.
how come there are two cases?
Another FIR father is lodged, Lordship.
No, first time at the year December, and next one is May. After he
First
returned back.
one case.
Yes,
That
she
was
came back.
That
continuing.
is the base.
She returned back and
Second
she was
time we
staying.
looked at
Again,
second-
she went, Lordship.
First time he went to the Madras. Second time he went to the Hyderabad,
Hyderabad.
and at the return police.
Then
What is
The same thing.
So she had
She was
wrote
sent
that.
in.
They call for a report from the trial court, only IO to be examined, my lord.
See, it's the same incident.
I am not on that, my lord.
One FIR. Bail.
I am
Again, she got
the
bail.
prosecution.
They are in love, so they will keep on going and keep on registering FIR.
No, POSCO is there. POSCO is there.
But second FIR is barred on the other back.
Yes.
No, it is not self-same.
No,
No, but they are in love. Even if I'll grant bail, again he'll run away. This girl. Another FIR.
Missing. Obviously, a father will give the missing report.
Till they are married, they'll keep on running like this. Once they are married, they'll never run.
That is separate as well.
Give them an opportunity. to
Now
marry.
she deposed against the
minor-
petitioner, my lord.
Minor garbage.
But right now.
Minor
The,
garbage that concern.
the petitioner is in petitioner is in the statement of victim under 164 it is recorded. She has entry has stated that he is in relationship with the petitioner. Earlier she eloped with the petitioner to Madras.
Yes, Chennai, Lordship.
Yeah?
Let's say Madras, Chennai.
Chennai. At that point in time, FIR was registered by the family member of the victim girl. In the said FIR, being PS case number 50, Balugaon PS case number 50 of 2022, the petitioner has already been granted bail by this court by order dated 20-3-2024 in BLAPL number 12972 of 2022. It appears the petitioner was enlarged on bail. He has again eloped with the same victim to Bangalore this time.
To Hyderabad.
Hyderabad. The family members have registered another FIR.
Missing FIR.
Another FIR being PS case number
126.
126 of
126.
120
of 2022.
29
PS case number 126 of 2020. Petitioner is in custody since
3/11/2022.
3/11
2020 20
23
22, Lordship.
22. 22.
Yes, Lordship.
This is very hard. 22.
Court down will
the order dated 28-3-2024 passed by the coordinate bench in the earlier FIR, and also there is the document placed
So that girl was pregnant also.
This is an apparent case of second FIR for the similar offence committed similar offence committed by the petitioner. Without further regarding to the fact that the petitioner is already in custody since 3/11/2022, and nature of allegations made against her, and the fact that the victim herself has stated in her statement on 164 that voluntarily eloped with the petitioner. I am inclined to admit the petitioner on bail accordingly. the
Let's see that girl was 5 months pregnant.
Whatever.
Then once you will get the bail, she will not take care. That is the another aspect, Lordship.
But the fact remains that repeated FI.
Maybe Lordship, that is minor girl, Lordship.
Let them marry. Yes.
Lordship, only take care of that girl.
A bail application, how can I pass? She will take care of the child.
That should be condition for that only I am saying. Because that is minor girl.
But they are
Once,
still in love.
once you will get the bail, no, she will not, you will not take care of her. That is the another difficulty.
So that is what the family members have created problem for the couple by repeating lodging FI. They have not achieved anything, and this boy must be now annoyed because he remained in custody for 2 years at the instance of ego of the family member. They are in relationship. There is a child. They should have left these young people to live their life. Only because of the ego of parents, the life of the girl as well as the child as well as this boy is spoiled. This is what is apparent from this. Leave it there. Let them have their own life. Next.
Condition may be posed. Each day you will appear in the trial, my lord.
It is Mr. Saul and counsel for the informant submits that the trial is at the fake end, and the petitioner therefore is directed to appear before the court below on each date appearing without fail. Without fail. Yes.
May I please, Your Lordship?
Judgment has been reserved by.
Yes, my lord. Judgment has been reserved.
33, na? 33. In the present matter, the coordinate bench of this court has heard the matter at length and reserved the judgment on 19/3/2020.
19/7.
7.
Yes, 19/7/2020.
Not order is not 19/7, which is reflecting in the website of official website of this court. Therefore, leave the matter before the same bench, subject to permission of court.
Grateful, my lords.
34. 25, I may be pardoned.
Yes, sorry. Yes.
Item 75, it will not reach, my lords. I have got a parted matter after lunch.
75 note for Rakta.
Let
when
it
it comes, they remind.
Yes, my lords, week after next time.
Yes, I'll like one.
Oblige, my lords. 70.
I have
Interim
put it
auditors,
down.
them I have
Yes,
associate, he will apprise your lordship.
Yes.
Oblige.
34.
34.
May I plead, your lordship? My lord, petitioner are inside custody since 15/9/2023.
15/9.
My lord.
Yes.
There are 47 charge sheeted witness, my lord. There are 47 charge sheeted witness. One of them is eyewitness and another of them is injured witness, my lord. And the case is arising out of a civil dispute. Civil dispute and regarding
What are the injuries? Show me.
my lord, have a glance to page number
307.
Death. 307 is yours. 302, 307. Yes.
Died, huh?
Yes, my lord. My lord, have a glance to page number.
Brutally they have assaulted. Brutal they have
Brutally, my lord, have a glance to page number 44, my lord.
40?
The 44. The injured witness.
Yes. Yes. Yes, sir.
My lord, more, may I read, my lord? More नाम सुरेंद्र साहू, पिता स्वर्गत वासुदेव साहू, निवासी.
Come to the relevant part.
My lord.
Yes. कुंजबिहारी साहू तांको जमी
मोर
पाखरे
बापा वासुदेव साहू आमर निज जमी को जाइथिले सेही समय आम गाँव कुंजबिहारी साहू द पिटिशनर पिता कालिया साहू रंजन साहू रंजित साहू राजेंद्र साहू पिता कुंजबिहारी साहू ऑल आर द फैमिली मेंबर्स माय लॉर्ड तांको जमी पाखरे उपस्थित थिले मोर बापा वासुदेव साहू निज निज जमी रे पानी काटिबारु उभयଙ୍କ ମଧ୍ୟ ଯୁକ୍ତିତର୍କ ହୋଇଥିଲା ସେ ସମୟରେ ସେମାନେ ମତେ ମାରିବାକୁ ଆସିଲେ मोर बापा भୟରେ ଘରକୁ ପଳେଇ ଆସିଲେ କିନ୍ତୁ କୁଞ୍ଜବିହାରୀ ସାହୁ ରଞ୍ଜନ ସାହୁ ରଞ୍ଜିତ ଓ ରାଜେନ୍ଦ୍ର ସାହୁ ଅତ୍ୟନ୍ତ ରାଗ ହୋଇ କାହିଁକି ଆମ ଜମିରେ ପାଣି କାଟିଲୁ କହି
तोर जमी को पानी नेलु कही आम घर सामने मोर बापा को तते आज जीवन में मारिदेबू कही दुईटी फार्सा माइल इट इज इम्पोर्टाट दुईटी फार्सा निज घर बाहर करी मोर बापा को निश्चित माड़ मारी बेकर मुंडे फार्सा मारत आक्रमण कले और मु मोर बापा को बचाइक जीवार मते फार्सा आक्रमण कले फल मोर बेक और मुंड गुरुतर रक्ताक्त आघात पाइला तापर मोर बीरमहाराजपुर डाक्तखाना all these things, my lord. DET first, that means they are not the petitioner in this case, my lord. My lord, have a glance to.
Who all are they?
They are, my lord, have a glance to.
Ranji Sahu, Rajan Sahu.
My lord, have a glance to page number.
Who are you? Kunja Bihari Sahu.
Kunja Bihari
He has
Sahu.
been also charge sheeted on 302.
302, my lord, but my lord, have a glance to the.
The injured witness has not taken the name of these people.
My lord.
No,
And
no.
have a glance to
He-
eyewitness,
that
my
they
lord.
are controlled.
Eyewitness. Page number
Injured
13. My
He
lord,
was, he was told to that persons and other two.
no, my lord.
No, what about these two people? What is the role
My lord,
ascribed to these
my lord,
people?
another.
The eyewitness said they ସେମାନେ ଆସିଲେ ଦୁଇ ଜଣ ଧରିଲେ ମାନେ ମାଇଲେ
Which
ଏଇ ଯେ this one which one my learner friend
No,
was reading.
no, my lord.
1 minute. No, yes will not do. Let us understand what is that. Where is the name? Where is the come to again 40.
42, my lord. 42, page 42.
42.
My lord.
42. Come to 42. Where does it say?
Sorry, 44.
No, 44 only.
44, my lord.
Yes.
मोर बापा वासुदेव
Bihari Sahu, Ranjan Sahu. More Bihari Sahu, Ranjan Sahu, Ranjit, Rajendra Sahu. What is your name?
Kunja Bihari Sahu. My lord, another eyewitness is there. Have a glance to that eyewitness. He is at 40.
Kunja Bihari, what is your name? Petitioner's name. And
Kunja Bihari Sahu.
And
Ranjan.
there are two, no? Ranjit also. But this witness has not taken the name of Kunja Bihari. And Kunja Bihari is there.
My lord, Rajendra Sahu also. My lord, in another eyewitness is there. One of the eyewitness.
But 44 they have said taken your name Kunja Bihari and Rajendra Sahu.
My lord, in 42, the wife of the petitioner is also present there.
Spot injury witness, he himself is injured. 307 is there. Says that you were there, you have beaten up mercilessly. What are you talking?
No, my lord, another thing. My lord, please.
These people are examined. These witnesses are not
No, it
examined.
is
No, trial has not been started.
trial not started. It is charge sheeted on lordship on 12 January 24.
12 January
24. And the rejection order is 18th January 24 with when at the time this charge sheet was not before the court.
Right. The petitioner is agreed by the order dated 1/8/2020, whereby his bail application has been turned off. The petitioners are in custody since 15/9/2023. After investigation, charge sheet has been filed on 12/1/2024. The perusal of the statement of injured witness indicates that the petitioners were directly involved in the crime, and the injured witness has made categorical allegation against the present petitioner. Therefore, I am not inclined to enlarge the petitioner on bail. However, liberty is granted to remove the bail plea after the examination of the injured witness. Injured witness and the eyewitnesses. Eyewitnesses. Since charge sheet has already been filed, it is expected that the trial court should do well to preferentially record the statement of the injured eyewitness. With this observation,
My lord, my appearance for the informant kindly be noted.
Appearance of yes.
Gratefully, lordship.
Next.
35.
I pray, my lord. I pray. I pray 1 week after, my lord.
Yeah. Another 5 minutes, at least 40 the continue to समय भी नहीं होगा.
36.
Yes.
36.
36. Non-APS for the petitioner in the interest of the state. 37.
It's a passover 36.
No, adjourn. Today there is no question of passover. So many matters that don't come. In the
Right.
bail matter, at least you should come. I can't wait for this. Huh?
376. But very good case.
For bail. He's not coming, then he's willing to stay for some more time. Let him.
No, item 37, I pray for next week, to enable to take instruction from the trial court advocate at Balangir.
Instruction regarding what?
That stage up, whether the trial has commenced or not.
Next week may not be possible. Adjourn, huh? At the request adjourn.
Let's pick it the week after then.
38.
Because it's a file since 1511. Week after.
We will adjust our board.
Oh,
according
that's
to
all
see
right.
what see, many matters are listed.
No,
nobody
that is there, that is there.
Matter is listed, argue. Otherwise, it will be adjourned, and according to our board's permit, we will list it. Not according to your.
No, no.
I have
Because,
to see thousands of cases.
No, that
you,
is there.
you have to see 1 or 2 cases of your. Adjust it and give it. Okay. 38. Withdraw. Yes.
Third week in only.
He'll adjust it and give it. Don't give him little time.
Azure.
Because the board is unmanageable.
Yes, that is there.
39. Yes. 39. Yes, sir. 39. What is this? FIR under what provision? 302. 376. 376 3. NDPS for the petitioner. In the interest of justice.
40. May I please your lordship?
Yes, sir.
Yes, my lord, in matter, the informant has also, the victim also appeared and matter has been amicably settled. In
What-
this regard, we have also.
What is the offense?
Offense 376. So there is some relation between the petitioner and the victim.
They are going to get married.
Marriage has not been, but there is not yet been done because petitioner is in custody. After there's no grievance of the.
Not yet been married. Marriage has not been solemnized yet.
No, that's right. But with
Yes, my lord. To the airport, he submitted a affidavit for it.
where is that affidavit?
Affidavit on 19/3 to
This victim, huh?
2021.
Victim has filed.
Where is that? What have you said? One victim is in love. We were treating for marriage, but it's due to some.
On the other.
Refused to marry.
Oh,
Yes.
no.
Yes. Well, wait. Huh? They let them marry. Why unnecessary? Right on. No petition. Let the council for the petition submit that no other bail application is pending before any other court. The allegation against the petitioner in the FIR is, okay? During the pendency of notice was issued to the opposite
Already
party.
appeared.
This court issued notice to the victim. The victim, who is 21-year-old girl, has now filed an affidavit inter alia stating as under 2 to 4. Para 2 to 4. Petitioner is in custody since?
Lord. Lord, 8/1/24.
8/1/24. Okay. And charge sheet has already been filed?
Charge sheet has been filed.
Charge sheet in the present case has already been filed. On, do you have the date? On sir. Regarding had to the fact that the victim.
On
Charge sheet 29th February 2024.
On regarding had to the fact that the petitioner is in custody since 8/1/2024, and the fact that the victim girl has filed an affidavit before this court inter alia stating that she is desirous to marry with the petitioner once the petitioner is enlarged on bail.
She's 4th month pregnant.
Huh?
She's also pregnant.
And she is also pregnant.
No. That was.
4 months.
Why should I write that? What line? Inclined to admit the petition on bail accordingly. Yes.
The 164 statement, the victim girl has stated there, ମୁଁ ଓ କାଳିଆ ପରସ୍ପରକୁ ଭଲ ପାଉଥିଲୁ। ବାପା କାଳିଆକୁ 25,000 ଟଙ୍କା ଦେବା ପାଇଁ ରାଜି ହେଲେ ମତେ ତାଙ୍କ ଘରକୁ ନେବା ପାଇଁ, କିନ୍ତୁ ସେ ରାଜି ହେଲେନି। ଏହାପରେ ବାପା ପୋଲିସ ଥାନାରେ ଯାଇ କେସ୍ ଦେଇଛନ୍ତି। ଏତିକି ମାନେ what happened, they have earlier love affairs, my lord. They are ready for the marriage, madam. But petitioner stated after attaining our majority we will get married, but village people forced them.
What is the age of this girl?
14 years, madam. 14 years.
Yes, what is it?
14 years, my lord.
And this boy is 20 years.
Yes, madam.
What to do? He will catch October 23. Young boy.
And my lord, there is a 164, yes, admitted.
164 is there.
But the criminal girl,
That's right, technically done. Technically offense is done, but about what did it say?
Trial has not been started, madam.
Charge is in frame.
Charge frame, madam.
Charge is in frame.
Madam.
To me, 164.
Yes,
but in a very similar matter, long time back, Mr. My Lord Justice Deepak Mishra, as he then was opposing. I was opposing a bail appellate like that. That girl was 14, the gentleman was 36.
Oh, then she age difference.
No, my lord, still, her ladyship, AK Party said that now that there's another aspect to that matter. You better make sure that that first divorce is gone through and let her get married. And
See,
his son now
these are very harsh cases, you know, young children, 20 years boy, and they don't realize what they do. What to do? You can't keep them in jail also, you are not achieving anything. And see the other case in the morning, 7-year girl and 38 years. On those cases,
that's
no interest. But in these kind of cases, you know, you have to be little.
I shouted at my rooftop, my lord. Mrs. Justice Party never heard me.
What to do? This is the harsh reality.
In this position, marriage cannot be held. Because till now, she is minor girl.
After attaining majority, we are ready to accept her, my lord.
We don't know what will happen after. Marriage is successful or not. Even today, he's 17. 14, na?
14, my lord.
Right up. The petition is accused in solution. The second paragraph, what is the submit that there is no other bail application, bail plea pending before any other. The allegation against the petitioner is dismissed. After investigation, charge sheet has been filed on. The sheet has been filed on. When the charge sheet is filed? Charge sheet is filed on 6/12/2020. The statement of the victim girl has been recorded under section 1 CRPC. She has stated in her statement that she has been in a relationship with the petitioner. Kalia, what is your name? Kalia. His father relationship, and when his father, her father, demanded 25,000 rupees from the accused. Since he has not paid the amount, Papa Police since the petitioner refused to pay the said amount, the father, their father has registered the FIR against him, against the petitioner, against the petitioner. The petitioner is in custody since 10/10/2023. Medical evidence?
Medical evidence there, my lord. In page 59, I think.
What
58
does-
or 59. my
What
lord.
does it say?
Nothing is there, my lord.
In the, even in the medical evidence, both of them were regular.
Examined, my lord.
They are habituated regular sexual. Nothing incriminating come against the petitioner regarding head to the length of custody. And also, it is
Matter at, my lord had picked up, in fact, my learned friend was, my lord, I will only state, I'll make things easier for him.
But there was a request.
Yes,
made.
I, difficulty of mine is, my lord, I left a matter, and in fact, one matter where my lord, as he then was as appeared in the court as 106 today. I took an adjournment and came here, rushed here because of the fact that, my lord, he cannot, I mean, he's a superannuated DSP police. I'll just, 3 submissions I'll make. 15 minutes is my argument, my lord.
What we can do is let him conclude the argument.
Yes.
I'll accommodate you.
Yes.
Another day you argue.
Yes.
That's a better idea.
Yes.
Let us make him free.
All the Special Court Act convicted confiscation matters have been entrusted to Mr. Simon Das.
He cannot appear against me.
Because he cannot conduct this case because of my not senior friend. So the file was sent to the
My lord, he's not my friend.
entrusted me to conduct this case, and I got the file last week.
I know, I understand it.
And
That
last week only. So I have received the file and I have not gone through the same.
Yes, yes.
There are 17 PWs and 8 numbers of PW.
My lord,
I have not
I'm making things easier for him. I will not go beyond 1 PW and I'll not go into facts at all.
Note
After
down,
that, you can.
and I will accommodate you whenever you want. No problem. You record it. It will
You
be
record it.
easier for you to reply.
Yes, I want him to reply.
Instead of reading everything, whatever he says, I answer to that. Your work is
Over, is it?
over.
It'll be much easier, my lord.
Please note down what he thinks. Yes.
It has partner. So I will.
Give me partner only.
Only I need to 2 weeks time.
No problem.
No, 2 weeks time.
I'll list it. Let him complete.
The DA case. So
Let him complete because he has adjusted his, calendar and his committee was fixed for 2 o'clock. Let us complete. How much time will you take?
20 minutes, man.
20 minutes.
20, 25 minutes maximum. man.
Vigilance matter कितना है? 10 bail matters. Huh? 10 bail matters are there that requires committee. But it will take 5 minutes.
Only miscellaneous small matters. So then I can just run through the list because there are bail matters and all. About 10 matters are there. Let me run through, then I can.
Yes, yes.
If it stretches little bit, also no problem.
Yes.
Let me complete it.
Yes. In fact, I was thinking of suggesting that.
Yes, it's a better idea. Yes. Yes. Continue.
41.
41. Sir,
May I please, my lord? My lord, CDG record, CDG not with me, lordship. 41, 40.
Offense?
My lord, it's a NDPS.
Recovery?
257 kg. My lord, the boy is a 20-year-old boy, but let the CD come.
But if it crosses 100 kilo, then CD is required.
CD.
Otherwise, less than 100,
My lord, let the CD come.
CD. Let CD 1 week after. Let the
Obliged.
42.
May please, your lordship. On behalf of Mr. Durga Datta Mahapatra, I may be permitted.
Sorry?
On behalf of Mr. Durga Datta Mahapatra,
Yes, you are.
here in this case, my lord, initially this case was registered offense under section.
Here also 306 with CDG not with me, lordship.
363.
Item 42 also.
363 and 306 of I.
306 is there.
Last order CD and PM report called.
CD come? CD. Okay. CD. 43. Yes. 43. What are the offenses?
265 kg.
265
65 kg.
Yes.
Man.
Yes. 43.
My lord.
43. Yes.
My lord, here my lord. চার্জশিটটা ফাইল করে দিই বরাবর আরে ফাইল করি চার্জশিট হ্যাঁ ফাইল করি ଯିବା ଚାର୍ଜশিট চার্জশিট is my lord annexure 2
Also the one which I said call for CD.
Yeah, no,
okay diary আসেনি কই
yes
Case diary. Let us see. That's what I said. Case
no he my lord and friend say চার্জশিট
so let it come.
Yes.
Next. CD. Yes. 44.
when my lord
He give me one week after.
ডেট দিতে পারবে ডেট
302.
302 34 IPC, my lord. Case there is not.
Case diary is there.
No, my lord.
Call for case diary. We'll see.
My lord.
Focus. Call for case diary. Yes.
45.
Your Lordship, are praying for a Passover.
What Passover at this moment? You tell me what is.
Your Lordship, on the previous occasion, Your Lordship had directed the state to produce the CD and postmortem.
CD has come. So least it after field. Or at the request, please. Yes. Next.
46. 45.
May clear action. The present petition entity case under 3762 and 506. I think an inside custody since 10/1/2024, my lord. He has got love affairs with the victim girl, and thereafter he kept physical relationship with them. The medical report also does not support the ocular statement of the victim girl.
164 you have?
No, my lord.
Oh, CD is there, Mr. Raghuda?
CD is there, my lord.
But 164 treatment, my lord, not with you.
Foxo is not there?
No, my lord. 21 is
372 N.
Okay. Just see what are the allegations. This boy is 24 years.
yes, ma'am.
See 164. He's in custody since
10/1/2024, my lord.
10/1/24.
24.
Just see. We have 164.
One not 161 is there, my lord, not 160.
164 you are done or what?
This file assigned to my friend, my lord, is not there for that. What happened?
Shall I put it next week?
Next week, my lord.
Oh,
Mr. Patra,
Monday,
Mr. Patra.
Monday, Tuesday. Monday, Tuesday. Let him read it. Okay. Don't give longer time because 376 24-year-old man and the girl is 21 year. If 164, if something is there, we'll grant it.
164.
We'll grant it. Yes.
47.
I pray for Passover on behalf of Mr. Tripathi 47 and 48, my lord. Just short Passover, my lord. Just 200. Barely place on another court, my lord.
I'll finish up the board, then I'll hear the.
Pray for short Passover.
You tell me, then I'll adjourn it. On request, I'll adjourn it.
47 and 48. Just
Adjourn it for both the matters.
my lord.
Both the matters I'm adjourning it because specially fixed matters are there. I'll have to hear that.
Pray for special date, my lord.
Yes. 49.
Problem.
It's was entry in well and the surrender in 1824, my lord. Here is the surrender certificate.
Yes.
And I pray for next week for hearing.
Only you tell me what do you have to surrender. You file it, surrender. Give me. File it. File it. Interim order was granted when?
11/7/24.
Pursuant to the interim order, the petitioner was released on interim bail, and he has already surrendered. it will get placed on record, which is taken out of taken out of. What about the main matter?
Main matter I prefer next week for hearing.
Not next week. Chalo, anyway, you enjoyed
Not ready.
interim bill for some time. Edited it. Long time.
Item 50.
September. Yes.
May please, Your Lordship. My lord, this is an allegation under section 76 and section 6 of the POCSO. The present petitioner,
Victim says,
my lord,
age of the victim.
my lord, the age of the victim is 17 years.
17.
Yes, my lord.
You are 23.
I am 23.
Yes.
And is in custody since
Since
10/10/2023.
10/10.
2023, my lord.
Show me 164.
My lord.
You have?
Yes, my lord.
Read it. Do you have another copy?
Yes, my lord.
Read it. Read the relevant part.
मते घासी नायक घरे प्राय 3 दिन रखिला इच्छा विरोध रे मो से शारीरिक संपर्क रखिला
All the matters.
The matter from February. Fast track once after the.
Leave this week, next week, top row. Top row, all the 3 matters. Monday top. All the
matter
no, sorry, all the matters. All the matters. You come so that at least you can come in the name of 3 matters. Otherwise, you don't come. That's the problem. Yes.
Grateful.
On the ground of mother illness.
Mother illness.
My lord.
Verification.
He is the only.
Verification has been done. See.
He is the only son, my lord. No, father also died.
What has happened to your mother?
The old age person, my lord.
Chest pain.
My lord. And petitioner is custody since 14/5/2020.
What is the age of your mother?
55 years, not chest pain. That is mentioned in the OPD certificate.
Verified. Not a big problem. He is also not so old. Only 55 years. The certificate says only chest pain.
4 years he is in custody, my lord.
That is a different story on merit.
And
You are talking about interim pain. What is the recovery?
recovery.
This is
302 case.
302.
302.
Miller. Eyewitnesses are there.
What is the stage of the trial?
Trial is going on, my lord.
How many witnesses have already?
Total charge sheet wrote, Miller.
Hmm? 21.
21.
21. How many of them are examined right now?
That is.
How many witnesses have already been examined?
That instruction not come, but 15 or 20. I have no.
Well, verify the health position. Will see. Yes.
It can kindly be taken out tomorrow.
Not tomorrow. Verification it takes time. Verification takes time. Yes.
52.
Yes.
Next week, my lord.
Well, we'll give a date.
My lord, 52, my lord. Concession bail, my lord. The AD unserved notice writ.
What on the ground?
My lord, the ground, my lord, after obtaining, my lord, anticipated bail, all the opposite parties, my lord, went to the police station and ransacked the police station and assaulted police personnel.
Yes.
Thereafter, on the way, they also assaulted another police personnel. And AD not returned from the, my lord, opposite partner 5, 6, and 7. Others.
In respect of 4 accused persons, notice has been served, but due to illness of the mother of the counsel, Miller, you could not come and approach me to for.
No, then I'll issue warrants then.
He will appear that mother counsel mother illness.
And bail is granted. Asked to appear in the police station. You go and ransack the police
Next week any day, I will appear.
This is a matter where I can say.
Yes, madam, I am conscious on that. Next week, any day. madam.
Oh, affairs are registered.
Two affairs, man, registered.
What is this? You are asked to go and appear in the police station. All of you went there and ransacked the police station, beaten the police and all.
That while returning on the way, another police officer going in motorcycle, they have also assaulted to him. For that, another case registered.
And next week, any day, we will appear.
If this is
On instruction of Taraprasad Maharaj.
okay, I'll put it on your request.
Next week, any day, he will appear.
Friday, Friday.
Appear for the accused.
On request, Sergeant.
Married.
Yes. 53.
Your Lordship, an item 53 on behalf of Mr. Sarthak Naik appearing for the petitioner, Your Lordship. I'm praying for 1 week's time to file a reply to the counter filed by the opposite party, Your Lordship.
Reply to 1 week.
I'm much
we have
obliged, Your Lord.
Respondent, 1 week time is sought for filing reply. Reply to what?
Reply to the counter filed by the opposite party, Your Lordship. CBI is the petitioner here. This is regarding the cancellation of bail, Your Lordship.
Response to the objection filed by
Yes.
opposite party.
Yes, sir.
Number 2. At least the matter after. 54.
My Lordship, please. My Lordship, please. My Lord, the petitioner filing for modification of the order, my Lord, passed by the London Court below, Lordship.
Which order?
My Lord, term and condition.
Which condition? Page?
Lordship, running page 13, Lordship.
1-3.
Lordship.
Which condition?
Condition number 1, my Lord. They shall appear before the court on each date of posting, Lordship. Lordship, the petitioner is residing
They
at
appear before the court and each date of hearing. Yes.
Yes, Lordship. Lordship, petitioner is residing at Bhubaneswar, Kendrapada, Lordship. And the matter is pending before district of Korapur, Lordship.
What are the offences?
Lordship,
493 or the
493.
but in fact, one case of 2018, they have
Yes,
religion
Lordship.
bail, did not appear, for which NBW issued. In persons and
Already-
and directed to appropriate permanent custom.
my Lord,
CBI
already London SDG grant the bail, Lordship.
When this condition is there, you are not appearing. If I remove this condition, you will never appear.
Lordship, already London SDG, London Court will already grant the bail. Lordship, and
Bail is all right,
Lordship,
but
Lordship.
this is the condition.
Lordship,
Despite this
my-
condition,
my
NBW was issued. He is
No,
not
old
appeared.
age person is there. Petition number 2 and petition number 2 and 3, Lordship, old age.
enrolled cancel and they
Lord,
are
83
allowed
years
to go
old, 75 years old person. So, Lordship,
73, 53, 46.
Lordship.
83.
83. Petition number 2 is 83.
For 2 and 3, I'll
370% there.
2 and 3, I will modify.
Lordship,
1, I'll
4
not.
and 5, Lordship. Lordship
And
is a
this is
sister in law, Lordship.
an
Because of
application under section 430.
through and history, Lordship.
1 minute, 439(2) of CRPC, seeking variation of the bail condition number 1. Bail condition number 1, which reads as under. Where is that? 13. Page 13,
Lordship.
reads as under. Then counsel for the petitioner submits that insofar as the petition number 2 and 3 are concerned, they are senior citizens of 73 and 83 years respectively. So traveling to Koraput for fetching the trial is on each date of hearing is a huge problem for them. Therefore, he seeks variation of the bail condition. Taking the fact that the petition number 2 and 3 are senior citizens, I am inclined to modify the bail condition, and they shall appear before the
Through their
through the
filing 370 petition.
council by moving appropriate application.
And as and when required by the court, they
And it is made clear that the agent, when the court requires their presence, they shall appear before the court. Insofar as petition number 1 is concerned, he is the husband of the opposite party number 2. He has to appear before the court, and agent when on a regular day, if he has some difficulty, he can move appropriate application for exemption or for that particular day.
Lordship, 1 and 4 and 5, Lordship, distance between 700 through VC appeal. Lordship, through VC.
No, I have given you.
Lordship, because of 700 around.
Other accused persons are concerned. Not one other accused person. 2 and 3 pura complete. Okay. You move application under 317 or something.
Lordship,
If any such application for exemption from personal appearance is moved before the trial court by the other remaining, the same shall be considered on its own merit. Yes. Next.
Lordship, Annexure 1 is original copy returned to. Annexure 1 is file original copy to return to.
Original copy of what?
Annexure 1 is Lordship.
Or the original certificate copy of Annexure 1 can be returned, replaced by a photocopy. Yes. Huh? Oh, this is a paperless copy. You scan copy of file. Where is the original? Why are you making that statement? What was the
But I have already filed physical copy already filed. So Lordship.
I don't know. These are yes.
55.
Developed.
No notice could not be issued due to shortage of postal staff.
There must be stay.
Already the amount has been paid.
Is there any stay?
Yes.
How many days? 3-4 days you have taken. What is this case is about? For
Washing, yes, sir. For under DB Act, there was a mutual divorce in the year 2009. In the year 2017, the wife filed for DB Act under the domestic violence. So for passing of this order.
2017, this matter is pending. Every time you are taking time, you have not even cured the defect.
So I need some time.
It seems you are not interested. You know, this matter is pending since 2000.
The defect already removed, sir. Next date, any date, next week, sir. Please.
Defects, कितना defects? 57, no? 57. 55. Notice could not be issued to opposite party. Number 2, due to the shortage of postal stamp. Shortage of postal stamp in the counsel for the petitioner seeks agreement to cure this said defect. If the defect is not cured within 2 working days, the petition shall be dismissed without further reference to the court. If the defect is cured, then we see matter. Yes.
56.
Much obliged, Lordship.
6 minutes on behalf of my colleague, Mr. Maharana. Can you take note day after tomorrow? Or it can be added in the weekly list. This is what I was requested.
Friday.
The covered case. There is nothing much for the business to do.
In respect to the co-accused proceeding has first lack of sanction.
Srikanta Prusti. This is Srikanta Prusti. I passed regarding
lack of sanction proceeding has been passed.
Okay. Show me that.
They were not charge sheeted. They are named.
If it is a covered case, why?
So far that coal methods. So I was doing other matter, but this case may taken out some other time. Mr. Maharana will do it. But
Chittaranjan Das. Okay, you are relying upon Chittaranjan Das.
Yes, madam.
No, in fact, in both the cases,
Recently I passed some order.
in fact, in both the cases, I was the counsel. I got the point, but I was requested by my lord friend, Mr. Maharana. On Friday.
Covered judgment, Chittaranjan Das.
So far, my case.
And I may pardon Friday at 2 o'clock.
Not 2 o'clock. Whenever it reaches. In the morning, it may reach in the morning also. Put it in the because covered case is not to be argued.
Yes. Interim order to continue.
Not to continue. Yes.
57.
And get the judgment which I passed that also.
Yes,
please
yes,
say,
madam.
so that
Yes, madam. Yes, madam.
part of it can be copy paste.
Yes, madam. Yes,
I
madam.
cannot.
Yes, 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 madam.
My lord,
50?
My lord, 57, this is a matrimonial dispute and amicably settled between the parties, for which I have filed
Where are
a
they?
petition. My lord, my learned friend is appearing for the OP number 2, my lord, Prachit
Where are
Tripathi.
they? They come?
She has not come. Who did ask for you?
Yeah, any time.
Monday?
You
Monday?
bring them tomorrow also? How does?
Tomorrow?
498, na?
No, my lord.
No, no.
376B. Wife has lost the affair against her husband.
Husband.
And divorce also. Divorce allowed.
Divorce allowed.
Call them by tomorrow day.
1 week timeline.
1 week.
Next week.
That may be fixed so that
Date fix.
58.
It's 58 on behalf of Mr. Maharana, day after tomorrow.
Some defects are crept in.
Grateful.
Day after tomorrow.
No, no. We'll see. How can we?
As the Lordship, sir.
Mr. Marana is not.
Yes, ma'am.
59.
Yes. Hmm.
59.
This matter is pending every time adjournment.
Yes, my lord, and last petition will also be directed to remove the defect that has not been done. And 376 2F for passing for FIR. FIR and investigation.
Now, how many defects are there? Just see. 59, na?
Yes, my lord. Defect number 6 and 19.
What is 6 and 19? Copy. Copy the he has got it. Next, 19.
19.
My lord, earlier petition was
This matter is pending since you don't take things of the pending since 23/8/2023. The matter has been adjourned time to time on the request of the counsel for the petition. None appears for the petitioner today. In the interest of justice, last opportunity is granted for the petitioner to pursue the matter. Even defects are not cured. Defects are, please the matter.
Arjun.
60.
Arjun. Defectively removed within 3 days.
What are the defects? These defects are curable. 16, huh?
Minor.
6 and 19, minor. You tell me. Forget about the defects. What is the matter?
item number.
Is there any substance? If there is substance, then
Copy not serving. Right now you're.
Right now.
Copy right now it's serving.
From 19 within 3 days.
in September 23 you filed. This is for quashing.
Passing of paper, then I have to take instruction whether the charge sheet has been submitted, the charge sheet submitted, then it will.
Charge sheet?
I have to take instruction.
Received the copy right.
Then counsel for the petitioner seeks an adjournment to cure the defects and seek instruction regarding the status of the investigation. Status of the investigation. Please the matter make to be Friday. Right.
61.
Okay.
Item 59. Item 59.
Item
59.
59 what?
Arjun.
Minor defects.
Defects you didn't appear. Cure the defects and yes.
61.
61 may I please?
Yes.
Bishop, as per the lordship last day, notice was issued to opposite party number 1 and as per the registry it has been marked sufficient.
What is this matter?
Lordship, this is regarding, I'm challenging the order rejecting my prayer for discharge. Lordship, I also, my lords, I have given the entire bunch of documents that was annexed in the lower court. The lordship permit, I will just give a quick recap.
What is this matter you tell me? Discharge application, why bunch of?
Lordship.
Lordship, initially a case was registered at Mangalabag PS for violation of provisions of TOHO Act, Transplantation of Human Organs Act, that took place in Visakhapatnam, Andhra Pradesh. Now, during that course of investigation, Lordship, I was picked up from Visakhapatnam, I was arrested and I was brought to Cuttack. Lordship, my wife filed a writ of habeas corpus before this honorable court challenging that arrest. Now, this honorable court have annexed that judgment also, held that that arrest is illegal and released me. And also, because it was a great...
Illegal, why? Because it was, your wife was not informed.
Wife was not informed also, and there was no ground for arresting me. As per section 40, the ground should be mentioned in the arrest memo. It was simply mentioned as found.
Ground. Come to the merits.
Mechanical ground. Now, Lordship, what has happened in this case, in that WPCRL, because it involved transplantation of illegal transplantation, this court took cognizance and gave certain guidelines to how to deal with the violation under these acts. Now, Lordship, what has happened? I'm just placing the relevant portion.
That those guidelines are for preventing the preventing this kind of a crime to happen.
Lordship.
But the crime
has happened.
But in this case, crime has already happened.
Exactly.
That has to be tested.
Lordship, no, I'm coming to that point. Now, what has happened? An FIR was lodged for this provision. Now, this honorable court held that FIR cannot be entered because it's a special statute. There are special provision under this act. A complaint case has to be filed. Police has no power to investigate or even accept the FIR because it's involved. My lords, organ transplantation, which is the expert लोकों involvement दरकार doctors माने authorization committee जोड़ा कि government of Odisha राची से करिबे special powers तांको दिया है as per this act. So police FIR is not maintainable at all. So this honorable court held FIR cannot be entertained for breach of any of the provisions of 1994 TOHO Act. First. Second, Mangalabag police officials are not authorized to investigate a case relating to the breach of any provisions of 1994 TOHO Act. Third, only a complaint petition is maintainable and the complaint petition is to be made.
A complaint is filed.
Lordship, I'm coming to again to that point. Yes, Your Lordship. As per this judgment, because this honorable court gave direction what to do next, ja hegala, tanko direction dele ka ko authorization committee ko ja heji. I'm just again reading the relevant portion. Last page 50 number, page number 50. The IO of this case, माने ए जोड़ा FIR जोड़ा थिला charge sheet माने तो submit है नतला investigation stage रे थिला. The this case is directed to take immediate step to file a complaint on the basis of materials already collected by him for the alleged violation of the provisions of 1994 TOHO Act before the appropriate authority. In connection with this case, the appropriate authority may himself investigate the complaint or enters the matter to the CBI for investigation. Once the appropriate authority or CBI on investigation finds prima facie materials that there is breach of any of the provisions of 1994 TOHO Act or the rules made thereunder, the appropriate authority or the CBI will file a complaint petition. Now, my entire case is, Your Lordship, what has happened in this case? After this judgment, the appropriate authority filed this complaint petition. When something is clearly barred, police cannot require, police cannot investigate. Only this honorable court directed whatever you have collected, you go and submit before the appropriate authority. Then appropriate authority ऊपर छड़ा इतला कि तू अपना निजे investigate करोगे ना CBI को दियोगे. What appropriate authority has done in this case? Simply 2 page रे कोटे complaint लिखी की police जहाँ दे इतला Lordship, I have annexed that bunch. से इटा को annexure करे की file कर देले. Now, my lords, when this entire bunch, whatever the police has collected is barred, then if Your Lordship will keep it aside, then my lords, any case is not made against me. Complaint case.
The appropriate authority might have applied the might have thought that these documents are relevant for the popular.
Maybe, sir, maybe Lordship, this is
relevant. Merely because it has passed through the police hand, so therefore you can't throw it.
No, it it मतलब यार गोटे थिला assistance purpose by use करा जाई परिबो but एटा को आपण complaint case रे evidence हिसाब रे केम use करिवे
That will be tested. That will be tested whether it is
Lordship, that is
relevant
my
or not
case
relevant.
is it cannot be tested, it cannot be looked into.
You make out a case for discharge. How can you be discharged in such a serious offense? How can you be
Lordship,
discharged?
Lordship.
Merely because, see, are you making a case due to non-compliance of the guidelines given by that court? The entire prosecution is vitiated.
My case is that, Your Lordship, because the guidelines have not been followed. What you have, entire power is given under this act to investigate. Upon pura full power achi. You have not investigated the case. You have simply annexed the investigation. The
Rather,
materials-
that order which you read out, that goes against you. And the court says that the appropriate authority can take the call. He has taken the call by filing a complaint.
But Lordship, when
That's
this
the problem with you.
no, where, my lords, I'm reading again.
Maybe contrary to the statute, but you have invited that finding for yourself.
Lordship, I'm reading again. The IO of this case is directed to take immediate step to file a complaint on the basis of materials already collected by him for the alleged violation of the provisions of 1994 TOO Act before the appropriate authority, not before the court, before appropriate authority. In connection with this case, the appropriate authority may himself investigate the complaint or enters the matter to the CBI for investigation. Where is that? Where is the
these document which he has filed? Tomorrow he will come to the witness box. He says that I investigated. I found this document which was placed before me, correct document.
This cannot be
and you
taken into
cross-examine.
consideration.
You cross-examine her and tell that you have not applied mine.
But Lordship, this
Then you will
document
come out.
cannot be taken into consideration as per the my lord's observation that FIR cannot be quashed.
Directly it could not have been. But for this observation, now it is. But for this observation, which you have invited. Try to appreciate the thin distinction.
If Lordship, that is the case, then Lordship, my another point is that even if this is accepted, let us, my lords, assume that this bunch of document is to be accepted. Now, Lordship,
yes,
kindly come to page number, Lordship, 35, Your Lordship. First, my lords, kindly have a glance. This is my lord's statement of M.S. Ravi Shankar. 35 of this, my lords, I have given the later. Upon direction on side and pore deithili, but a picture and nine.
Is there article? Why can't we see that the impugn order? Let us see what is the illegality.
Lordship, impugn order, Lordship.
All these things you have argued.
Lordship, I have the petition also. Every, my lord's ground was taken there also. Page 19 starts at 19.
What happened to the patient?
So the patient is alive. The who has taken the kidney is dead. He is accused number 1. That is the Lordship Jagabandhu Lenka.
Unauthorizedly, you have taken the kidney.
No, Lordship, no. There is no unauthorized
allegation. Kidney from one person and you translate in the other.
No, it's unauthorized. But in this case, a two Lordship.
What is the allegation?
Allegation.
Conduct surgery and that he was merely medical director. Duty was to just keep the arrangement in the. You have conducted the surgery.
No. I was not the, my lords. I was no one. I was a medical director. Again, my lords, what was my duty is also not. I mean, entire this sheet, pura record rate, more involvement of hospital rate. There is not a single document to that effect. My summation is I was a medical director. My duty was to keep all instruments and all the arrangements. I will read the 161 of the conducting doctors also, who has conducted the surgery.
Just see, come to the impugn order para page 2 and last paragraph.
What is illegal about it and what is wrong in it?
So page
Page 20, 20, 20.
20 selection.
Last paragraph. Heard both the sides.
Heard both the sides, peruse the case records and all connecting documents. In the instant case, the present accused was allegedly working as medical director of the hospital where the illegal act is alleged to have been occurred. Prima facie attracting the offences under section 19 and 20 of the TOO Act at the time of framing. Lordship, exactly what I'm saying. I was a medical director. Now more of means how can you connect me with this case?
Read further.
Lordship. At the time of framing of charge, magistrate is only to consider the materials available in record in order to consider the sufficiency of grounds for proceeding against the accused if a prima facie case is made out or not. Lordship, that is my argument is this: when prima facie case, Jodi
The
Lordship,
trial court has rightly taken the view that the source of the document it has come is nothing to do with at the stage of framing of charge.
Lordship, my
Whatever
entire
documents
case
are
is
there, he has to apply the mind. A charge is made out or not.
Lordship, my entire
he has
case
taken
is
the
that
call.
only. My case is if this document is minus, I mean it's
So
keep it
that's
aside,
what,
prima facie case is
that's what
not
the
made out.
trial, that's what the trial court says that the source of the document he need not go into. He has to see the document. Then the source, you can question the witness. Where from he got all these things, you can put it
Lordship,
in
again,
the
it
trial.
will again means create another round of litigation.
Maybe
Because
what to do, that is the law. What
Lordship,
that's
Lordship, kindly have a glance at page 31 of this, my Lord's document.
Yes.
161 of Dr. M.S. Ravi Shankar. I, Shri Dr. M.S. I am working as nephrologist in Seven Hills Hospital, Private Limited, Visakhapatnam. I can very well recollect that I and my colleagues, Dr. Amit Saple and Dr. Alok Majumdar, had conducted transplantation of one kidney of recipient Mohan Chandra Lenka of Palasoni, Bhubaneswar. His wife Banita Lenka was donor as per documents produced by them. We have obtained Xerox copy of voter identity card and both donor and recipient. We had also obtained resident certificate of donor Banita Lenka to prove that she is actual wife and recipient Mohan Lenka. As we and our hospital was satisfied with those two documents and affidavit by donor and recipient, we did not ask for any other document in case of kidney transplantation between husband and wife.
I don't think I should interfere with this thing. You are on bail.
Lordship, I'm on bail. My lord, my 205 is also allowed, but this complainant is also not coming, my lords, for last 2 years. After this Asian resurfacing case open Thilabi, Lordship, no one is coming and it seems that they are not
I can
interested.
only help that I can give a direction to expedite the trial. To that extent, I can help. I don't think I should interfere in this case. Allegations are very.
There are no materials against me. That is, my lord.
Materials are there. Somehow the materials have come.
Absolutely
and
not
you have
single.
made that observation. The authorized officer
Even
can
if
do it.
Lordship,
Otherwise, the statute might have helped you.
Lordship, let us accept what Lordship, let us accept it. This will be accepted. Now, Lordship can have a glance to this material also. What material is against me? Let us accept this will be means taken into consideration by the trial court. Now, what is there against me in this?
You are the owner of the hospital.
No, Lordship.
You are the director. That is the.
I am the medical director. So, Lordship, they are private hospitals have a number of directors. Why me? That is the question I put to myself. Why me? I was not a surgeon.
You are the.
I was not sanctioning authority. I did not check the documents.
Right, you are the promoter director.
I was also not promoter. I have the list of directors. I was not also the director. I have the list of directors. Will Lordship want to have a glance? I can.
Where are the list of directors? This is which hospital? 7 years. 7 years. 7 years. And you don't have very good reputation also. Yes. List of directors only. List of directors, where are they? At the time of commission of offense.
Lordship.
Not now.
Immediately, my lords, actually, this is a subsequent CRLMC. First CRLMC was filed challenging the cognizance, which was actually dismissed. That's why, my lord, obtained this from the.
What is your name? What is your name?
Lordship, Chiranjeev Vidyabhushan.
Name. And
Dr. N. Prabhakar Babu.
Prabhakar Babu. Where is your name? Your name is not there. Your name is not there.
Lordship, I was, my lords, if your Lordship, a bunch of documents, police observation.
In this document which you have given, your name is not there. You are not even director.
My lords, I was a medical director. My work is just to, well, for example, lordship, but aji 10টা আছে তো সেই সার্জারি রিলেটেড কোন equipments
Then it is
private hospitals
you are the person who are supposed to supervise everything.
supervise lordship, but I am not the means documents में मुझे
I'll just expedite the. I don't think. You have argued so well, but what to do? You don't have a case. What do you say? And expedite.
lordship as it pleases, but I
Because if I write anything that may prejudice you, so it's better that not to write anything. And your apprehension, I'll record that it prolonged the trial.
petitioner is also 70 years old.
You have already you have already got bail. 205 is allowed. Let the trial proceed and expedite the trial. Why on this? I don't know. The petitioner has assailed the order dated 20th July 2023, passed by SDJM S. Cutter into CC case number 863 of 2014. Whereby his application, where is the impugn order? His application under section 245 2 of CRPC seeking discharge has been rejected. There are as many as 5 accused in the present case. The petitioner is the accused number of 5. The counsel for the petitioner has vehemently argued on various aspects of the matter, and he has also attacked very maintainability of complaint case initiated against him by the so-called appropriate authority. He has also taken me to the judgment of this court, judgment of this court initiated by his wife. Being read petition number, what is that read petition?
WPCRL 266 of 2014.
Can you give that? Can you which paragraph you said that paragraph? Which paragraph? Last paragraph you read?
At page 50, my lords.
50?
Pura last page of the judgment.
Where the court has said that
FIR is regarding FIR or
and he has and particularly pointed out to the para 15. This is 15. Para 48. 14. Actually, para 50. Up to judgment. 50 of the judgment which reads as under. The 55. Para 50 page. Representation criminal number 266 of 2014. He submitted that even the guidelines formulated by the court below in the insanity clouded the authority without application independently has filed the complaint case annexing all the documents collected by the police. If those documents taken off the record, no case is made out against the against him. I perused the documents placed on record and the judgment cited at the bar. I'm not. I find no infirmity in the impugn order, the trial court, while rejecting the application of the petitioner, has dealt with the requirements made by the petitioner in his application. The appropriate authority has filed complaint relying upon the documents collected by the police in the instance case, since the present case is special case is built up on the basis of documentary evidence. Obviously, the documents collected by the police assumes relevancy. Therefore, the competent authority has authorized, what is it? Authorized officer, appropriate authority has those documents filed the 262. Therefore, the trial court has rightly proceeded against the petitioner and declined to discharge the petitioner in the instant case. I find no infirmity in the present case, therefore the petitioner is dismissed. However, taking into the consideration the fact that the petitioner is 75 years,
70 Lordship.
70 years old, and he has been suffering this proceeding since 2014. It is expected that the trial court will be able to see that the trial is concluded expeditiously possible, or preferably within a period of 6 months. No, 6 months. How many witnesses are there? What is the stage? Have you taken a stay from here?
So it is pending after this filing of discharge petition. It is
Nothing is happening.
nothing is happening. There are 4 witness, my lords.
4 witnesses.
4.
Within 6 months.
Lordship, another point you will, Lordship, will kindly appreciate, although order has been, my lords, dictated. My lords, kindly come to page 52.
Yes, tell me what is.
Idhar my lords, kaun hai ji? Allegation more against ji, violation of 6B. That on verification, Madam, I'm reading the complaint petition, para 6E. That on verification of official record, it is ascertained that no such NOC has been issued either in favor of Shri Mohan Chandra Lenka, recipient, or in favor of Srimati Namita Naik by the undersigned, being the chairman of the authorization committee, as the said case has never been presented before the authorization committee for consideration. As per the provision contained by Rule 6B of the Transplantation of Human Organ Rules.
What do you want to say?
I want to say, my lords, 6B was not at all forced when this offense happened. It has been repealed by 2014 rules, which came into effect on 20 March 2014. This surgery took place on 3/4/2014 after 8 days. So this at that time 2014 rules was applicable, and in 2014 rule 6B has been done away with. This NOC Joda.
But you have not argued that point there before trial court.
That is actually not in the petition also. While researching, I found this point.
It's a good point. What to do?
Lordship, may adjourn the matter. Lordship, can appreciate the matter.
I will not adjourn. You give that a point, formulate that point. You give me. I'll leave it to the trial court to decide the issue at appropriate stage.
Lordship.
You formulate that point and date wise everything you give it. I'll incorporate that. You are recording your submission and leave it open to the trial court to decide this issue. Okay. Right. Give it today itself.
Lordship.
Yes. Thank you. 62. That's a very good point. Then no case is made out in it.
62. On behalf of Petitioner, I'm mentioning, my lord.
My lord, here, my lord, I have expression to appear in this matter. Here they have not served, though this application has been filed in 2023. Till date, they have not served the copy. This matter was earlier also listed. And here my friend has challenged that a raid was conducted by ED to declare that raid is illegal.
Let it be pending. You proceed with the trial. You convict him.
No, he is not absconding. He is not responding to our submissions. One of the co-accused fled away from India. LOC was issued. Like he was coming from Dubai to New Delhi. He was arrested at Delhi and he is absconding, my lord.
This man is also.
Yes, my lord.
What is this?
I don't
File
know.
If you don't cooperate with the investigation and don't cure the defects, this matter is
No, no,
pending.
I
I'll
will,
tell you,
no,
this matter is pending since when you file.
that is defect, my lord. I will defect
8/11,
2 weeks after.
2023.
This matter may be taken 1 week after, my lord. I will remove the defect.
He is not serving copy, but just filed it
And it's pending.
and not responding
And
to our summons.
adding to the statistics of this court.
Yes, my lord, I
it's
release
pending.
this matter 1 week after. I will file 1 week
I'm
after.
giving you only 2 work. You are automatically dismissed. Right on. This matter has been filed by the petitioner on 8/11/2023, and registry has pointed out various defects which has not yet been cured. When the matter is called up, the counsel for the petitioner seeks 1 week or more weeks time.
2 weeks time. 2 weeks time.
2 weeks time.
2 weeks.
Mr. Agarwal entered appearance on behalf of the
number
respondent
2.
and submits that in this petition, the petitioner has challenged the what is
Raid was conducted under section 17 of the PMLA Act.
the legality of the raid conducted by the respondent. At the same time, the present petitioner is absconding. Taking into consideration the aforementioned conditions of both the parties, I grant 2 days time to cure the defects.
2 weeks, my lord. 2 weeks
days.
certified.
I'm giving 2 working days. I'll see.
Certified copy is not given, my lord. 2 weeks
2
time.
working days to cure the defects. If the defects are not cured within 2 working days, the petition shall be dismissed without reference to the court. In the event the defects are cured, leave the matter after 2 weeks. Do it.
2 days it could not
No.
possible, my lord.
1 year, 2 years.
Certified copy has not
Then the
given.
message goes that the High Court is not able to decide the matter pending.
Fix 2 weeks
Why
after.
should the
One date
come
may
to the
fix.
institution?
10 months.
In the meantime, I will remove the defect.
You do it.
2 weeks time, my lord. Your lordship.
I have given 2 days, sir. What is the problem? What are the defects? If
One-
certified copy is not there, you move an application for exemption. What is the great deal about it? I don't understand. You don't want to do, that is a different story. Because these matters are pending from years, you don't cure the defect, and you are absconding in the same time. You can't go cure it, otherwise it will be automatically dismissed. Yes.
63.
Yes.
May please. Last occasion, your lordship directed to deposit 20K to the wife. Here is challenging the order of execution proceeding, my lord. That is the annexure 1, my lord.
Who is appearing for the wife? Yes. The interim maintenance.
No, my lord. Maintenance for execution. I am filed for the maintenance. Their file.
My lord, petitioner has challenged the order of the London court below only on the ground of limitation. And that limitation, my lord, very much covered under the COVID judgment of Honorable Supreme Court. So,
What is the area?
my lord, the total area amount was 45,000. And as per your direction, the petitioner has deposited 20,000 and the rest may be deposited.
Pay another finish it up unnecessary.
Well, I'm
You are
taking-
giving it to your wife only.
I'm taking instruction.
What instruction you gave 25,000? For 25,000, how many hearing you want?
Well, I am quoted to the judgment, my lord, also.
Forget about the judgment. I
That is
don't
the
want to go.
Page 7, my
No,
lord.
no, no.
I am also saying that, my lord. As per section 120, 125(3) and
I will
120.
not see the judgment. It is only 25,000 you have to give to your wife. Unnecessary, don't waste time up to the High Court like this. Give 25,000.
My lord, 1 week time to.
I'll give. You
1 week
have
time
problem,
to
I'll give
taking
you time.
instruction. I am taking instruction.
No instruction. I'll give you direction that 1 week, 2 week time, 3 weeks time, 1 month time. You tell me, I'll give that. For 25,000, you
Okay,
waste the
my
High
lord,
Court's
okay.
time like this. How much time you want?
1 month time. So that your lordship said, my lord. So I have to convince the client, my lord.
What convince? He has to pay.
My lord, 1 month time.
My lord,
Yes.
please, the opposite party wife is a housewife and he has no other source of income.
Madam,
so-
see, insofar as the maintenance, regular maintenance is concerned, he has to pay, he has been paying it. Okay? It is regarding the area.
Yes.
Arrears was 40,000 rupees.
Yes.
Okay. While issuing notice, I asked him to pay 20,000 rupees.
Yes.
And then how much is remained? 25.
25.
I knew that he'll come with all technical things. 25,000, 20,000 I recovered for you. Another 25,000 now I'm recovering. And maintenance is so far regular maintenance is concerned, he'll keep on paying. What is the problem with you? You have not asked
He
for
is not
enhancement.
paying the regular maintenance.
He has to pay that. That is the order. That is the.
I
He has
also
to pay.
paid, na? 20, as per order dated 23/2024. Your lordship directed to pay 20,000.
Right.
I also paid.
That was the arrear.
I'll pass that order. Right.
Thank you.
Petitioner is agreed by the order dated. Agreed by which order?
Order dated, my lord. 10/2023, my lord. Annexed 1.
What happened by this order?
This order, your lordship directed that the area amount was 1/9/2019 to 28/3/2023.
The petitioner is agreed by the order dated 10/4/2023 and 12/10/2023. The court below has directed the petitioner to pay the arrears of the maintenance to the opposite party. It appears the arrear is calculated to be 45,000. While issuance of notice, this court, while the order dated 28/3/2024 has passed the following order. Para 4. Para 2 and 4, 2, 3, 4, the Pura order. For the Pura order, pursuant to the aforementioned order dated 28/3/2024, the petitioner has already deposited 20,000 rupees. The counsel for the petitioner on query from the court has agreed to persuade his client to make good the further payment of 25,000 within a period of 1 month. 1 month. And he has, as per the order dated 20 March 2024, the petitioner is also liable to pay the regular maintenance, awarded by the court below. In view of thereof, the petition is disposed of with a directive to the petitioner to pay 25,000 rupees within a period of 4 weeks, and continuously, and also pay the maintenance to the opposite party without pay. With this observation, the petition is disposed. Yes. Yes.
May I please? In this case, the petitioner challenging the order dated 4/9/2023 passed by the learned ADJ Salehpur in criminal revision case number 2 by.
What happened? You tell me.
My lord, my revision petition has been rejected only on the ground of delay, my lord. And the delay was 6 months.
Revision against for which order?
What
was that order?
No, oh, sorry, my lord. Under Annex 1, that order is passed by the learned SDM Cuttack under section 133 of CRPC, my lord. 133.
Oh, what are you?
Against that order, I prefer the revision, and that has been rejected only on the ground of delay, my lord.
It is only the so-called notice was issued. Revision.
No,
That
no,
is
my
not
lord.
delay.
My lord. My lord, kindly have a glance to Annex 1, my lord.
Only so-called notice was issued under 133. Against that you went to revision court and revision court had rejected.
No, my lord, that final order has been passed.
Have you gone against the final order?
My lord.
No, just see. Just see, where is that order? Against which you have filed the revision. Where is that order? 16/9/2022 order.
My lord.
16/9/2022 order. Read it. Read it 16. What is this? What is the substantive order by which you got really agreed?
Colleague, adjourn to next week. I will further examine.
Adjourn to September. Don't treat and come.
65.
Case under section 138 NI Act, my lord. Permit to withdraw raise the point before the trial court appropriate stage, my lord.
Right. Let counsel for the petitioner seeks to withdraw the petition to raise all these points at the appropriate stage before the trial court. With this liberty, the petitioner is disposed of this.
Petitioner to complete orders. Orders on 2 matters.
What are the?
One appeal, one revision.
Only for orders.
For orders.
Small ones.
Also.
Time.
It's 67 on behalf of Mr. Srivas. We commence.
Why for it?
It's, yes, ma'am.
My lord, orders it has come because in the meantime, in the special court, the accused has been expired and the proceeding has been abated. Challenging the authorized officer order under section 17, appeal has been filed. And the proceeding, the property has been attached. My grievance is the legal heirs of the during presence of the appeal, the sole appellants have expired. I filed the miscase to continue the appeal. That's the appeal. The authorized officers appeal and to return back my properties. To my respect, my lord has directed me. I have got a decision to that effect. Since Mr. Das, he has also requested me. His operation will be on 16th.
What you are trying to say is the confiscation proceeding which was going on.
When I confiscation against the order passed by the authorized officer.
Principal accused has expired.
Principal accused has
expired. Now the legal
is not applicable.
Yes, that was the moot question. Yes, that was the moot question.
Got a decision that this is applicable and I will get back my properties. This honorable court's decision I have got.
That is contingent upon the outcome of the trial.
But the trial is
Trial you are convicted.
No, trial in the abated.
Trial abated.
Trial abated. Because he died. The principal accused have
Principal accused abated.
Then it has to be,
there's no specific provision in the act, perhaps. That was.
This is contingent upon the outcome of the trial.
Yes.
The accused dies.
Yes.
If accused dies, 394 doesn't apply there in the trial. Only convicted, then 394 you apply and.
Yes. Hardships are correct.
Since during trial he has died,
yes.
There is no question of he proving his innocence.
Yes.
So then what will you do with this proceeding?
Well, that
all the property has to be reverted back to it.
But they have to prove the source also, because these are all proceeds of
they
crime.
are the legal heirs.
But how suppose they can't prove and ultimately the accused would have been acquitted.
Yes.
It would have gone back.
Yes.
Now there is no question that the accused can't prove his innocence because he died.
But the source of that income and property also. Well, that is a moot question.
That is for the purpose interim
arrangement.
Interim.
Yes.
They have to prove their source, then it will be released.
Yes.
If they can't prove the source, then property goes.
Yes.
Till the main accused get acquitted.
Yes.
Isn't it? That is the scheme of law.
Yes.
But here, suppose you think that they could not prove. Okay, no problem. You confiscate all the property. But insofar as the main accused is concerned, he has died. He can't prove his innocence.
So there's peculiar circumstances.
Can you retain it for all times to come?
Peculiar circumstances, actually. So Das will reply in detail, So Das will reply in detail. Or she may call it the week commencing 19th.
Same situation here.
Yes, ma'am. Same situation.
Can you have the copy?
Same.
Copy.
Accused died during the trial.
Yes, ma'am. Para 10 and 13.
10 and 13.
10 and 13. And the first question, the legal question which arises in the appeal for adjudication whether the confiscation person has involved under Chapter 3 of Orissa Special Act 2006 shall continue against the persons in whose name property has alleged been acquired by them after his death and abatement of the criminal trial in his team. Then my lord come to para 10. 10 and 13.
Jointly opposition, it is clearly confession proceeding is to be made when established the leading evidence before the authorized officer that the properties or money both have been acquired by means of offences, and if the person affected in later acquitted the appellate court, then the property or money both are written to it. Whereas the confession proceeding appears to be contingent on the result of the criminal claim. It is initiated against the person affected by the person from chapter so. The acquittal of the person affected letter on entitles the release of such property in his favor. Ultimately, what happens?
Ultimately, the
So
property is
natural
returned.
corollary of the provision is that if there is no possibility of recording of a conviction, as in the case of death of
Order of the authorized officer was quashed.
conviction cannot be made as there is no possibility of the person is affected being convicted by the offence of the PC Act. Therefore, if the person affected or the accused in the criminal trial dies, the case abates against him, then the confiscation proceeding cannot be proceeded by the other person in whose name the alleged property or money which is amassed. Directly covered. Directly. Line to line, page to page. Whatever I say correctly. I'll expose it.
My lord, sir.
I'll record your.
My lord, sir, we may take up on
No, it's
recommencing
a-
19. my lord. No, one more chance, my lord. Mr. Das has something to, he has examined something. My lord. See.
Can you distinguish this?
I think Mr. Das may distinguish. I just pray, my lord, to be taken in the week commencing 19. On 16th, hopefully his plaster will be removed. On 16th, his plaster will be 19th, my lord. Week commencing 19th, my lord.
Directly covered.
My lord, on that day, they also may decide.
My lord, but keep
That
it
day
in,
I said this proposition.
Yes, sir.
Exactly.
my lord, but
Your
keep
lordship,
it in record.
and this observation,
If the
your-
confiscation is contingent upon the outcome of the trial,
Yes,
if accused goes,
yes.
then it has to come.
This, this view your lordship has expressed in the last occasion also.
My lord, I may keep it on record.
No, on that day you show me.
Yes.
My lord, I may pardon. Instead of week commencing, I may keep it 2021 as your lordship. I leave it to my lord.
21.
21.
Yes, ma'am.
20.
Deeply grateful.
21 first item.
Yes, my lord. My lord.
Both better same?
Only 67.
Only 67.
68? Oh, sorry.
Sir is there.
Oh, please.
First item.
21 or first item.
Deeply.
69?
69.
1 minute. Yes, a
Yes.
small modification is there. Yes, 69. What modification?
For 1970, directed to furnish the bank security of 3.5 lakhs. Total amount is 3.5 lakhs. Because so much. Yes.
Yeah, you want a substantial modification.
Yes, but I can verify for us. In this case,
This
he has not approached in a clean hand because he has manufactured many documents pertaining to LD and all this thing. They document, I'm subject to correction.
I know. See, 3.5 lakh.
Yes.
Subject to furnishing bank guarantee. You want
I
modification?
have sold my property and.
Give a copy, but I'm not.
Sorry.
Give a copy.
I'm giving.
Give a copy. I'm not going to do it. If you are a concession, I formulated
Your
that.
lordship, with much difficulty, my lord, he is not able to arrange that amount, my lord, because your lordship, that is why I filed with the undertaking.
Naturally, the consequence was that.
Yeah, because 3.5 lakhs. They purchased that court papers. That is not the issue. Whether I have sold my property or that is the issue. No, that's a.
I know that it was argued at length. I was not agreeing. Thereafter, this proposition was given. Then you agreed. Therefore, after pass the order. Today you can't come out and come and say, if you are agreed, you have a remedy. You know that.
And that amount is directly. My submission undertaking. So that is. No, sorry.
No undertaking, no indemnity bond.
Your lordship directed.
Indemnity is there. Indemnify, you have to indemnify. That's a different story. But bank guarantee, it was.
No, your
I
lordship,
propose you accepted.
It will be proved that it is.
No. I propose you accepted. Thereafter, I pass the order. Otherwise, I would have dismissed that day.
No, that is why I filed.
We'll see. You supply the copy. We'll see. Least it after 2 weeks.
It will improve, my lord. I should consider.
Yes. 68.
On each of us. But this is a direct link with the offense committee.
Yes.
Please.
Okay. See.
They sold it.
Yes, Mr. Mishra, are you mentioning something? What? Okay. Let us. Yes, sir. Mr. Das is there? Is there? Okay.
My lord, facts are like this, my lord.
Yes.
Before I go, my lord, just a bird's eye view of the matter, my lord. The petitioner was at the given point of time when his home was raided, was Deputy Superintendent of Police guard in Sambalpur. But these are facts, my lord, not no fiction. He was the movement of the file was there for him to be made the SP and posted in Kalahandi. But the date of the house search was 12/1 to 2006.
12/1
12/1 2006.
Yes.
The check period was 1/9/95 to 12/1/2006. The pre-check period was 6/6/76 to 31/12/94.
31?
12/94. Now, this joint service as a direct sub-inspector of police, where just before that, my lord, they enhanced the qualification to minimum graduate, and he got into it. OPS also, my lord, was done away with as direct recruit.
Yeah.
My lord, interestingly, my lord, may kindly see 21/2006 is the house arrest, the house search.
Yeah.
The FIR is registered on 17/7/2006. That's at page 1 of the paper book, volume 1. No explanation regarding this 6 months delay, my lord. No explanation. My lord, the sanction order.
It's a DA case.
DA case.
Generally, in DA case, they collect all documents, they evaluate everything, it takes time.
Yes, and all the documents.
It is not the offense, incidental offense.
Yes.
It is an offense relatable to a particular period.
Yes.
They collect the document, they evaluate everything, takes little time.
Yes.
So therefore, the FIR comes little later.
Yes. Whether 6 months is good time or not, my lord, is the question.
Yes.
My lord, the sanction order was issued on 6/4/2011.
6/4?
2011. My lord, can just see the distances, my lord. The sanction order is Exhibit 22, page.
Here, volume.
Exhibit 22, my lord, it's that documents volume.
Volume 2.
Volume 2. Exhibits 1 to 38. That is the volume.
Volume 2, no?
That's probably 2 or 3, I don't know. Deposition is volume 2. I think this was volume 3.
We have another volume. Volume 2.
2. 1 and 2.
Only 1 and 2 engineering the cost list here in the only 1 and 2.
Volume 2.
There are 2 volumes only. Huh? How many volumes are there? 2 volumes.
Volume 2. That must be volume 2 then. Why don't know? May have been retraced and accordingly, but.
Okay, volume 2. Page?
That might not be. Unfortunately, the pagination is not there.
Your instructing counsel should have done it.
Documents are not available both the volumes.
Page 21, my lord, probably. No, I don't think it can be 21 also, my lord. No, the volume.
See, Mr. Das, the problem is these are 2 volumes.
Yes.
And along with that, see the paper volumes. Then how will you go about it? And
No, my lord.
obnoxiously reading here and there will not.
No, my lord. These 2, my lord, my submission is very simple, my lord. First is that FIR. Second is the sanction order. and I'll take, my lord, deposition of the person who is the authority who signed the sanction order, and I will take to the investigating officers one paragraph, and I'll leave it to that.
Are you questioning the sanction itself?
Yes.
Okay.
I'm also questioning very interesting, my lord. Kindly see the sanction order. Has my lord got the sanction order? I'll give my copy, my lord.
I'll find out. What is the page?
The page somewhere in the middle, my lord. It can be in the roll call record also, my lord, I think. This is. I'm passing on the sanction order to my lord. My lord may see
No,
it.
but I can't keep your file
No.
while dictating the order.
No.
That's another problem.
No.
I have to mark it while dictating
Yes.
the order. It will be easier.
Yes.
I read here from here, there, and then.
Oh. All right, man.
Okay. I'll just find out exhibit
22.
22. I'll just find out. Volume. Open volume 2. Open volume 2.
Volume 2 तो ये था. Well, the lower court record must be there. The exhibit must be one volume there, my lord, and that must be paginated.
Yeah, I'll tell you what exactly the problem is. And the scanning business is outsourced to the other agencies. The agency people are not law-knowing people.
That's the
They obnoxiously scan and put here and there and all. It's very, very difficult to find out.
No, anyway, my lord, I will give a copy of that.
That's
sanction.
right. I'll see volume 3. We'll just check it out.
Exhibit 22. It is exhibit 22. The file LCR would have come also.
I can find out. Trial court record PCR.
झूठी exhibit तो मैं दे रहा हूँ ना मार कर देवे. That exhibit है.
We get it.
Oh, सब जगह अच्छी.
Exhibit
22, my lord.
Exhibit. Which exhibit you're talking about?
22. Sanction.
22.
Appeal memo. It is page 152.
And I can get it.
The list is.
Got hold of the exhibit 3. यहाँ कहाँ जाता है? Yes, sir. Somehow I got it.
Well, then no dispute over the fact. The appointing authority of the sub-inspector of police, my lord, is the governor of Odisha.
See, the scanning I saw from exhibit 3, thereafter exhibit 67, exhibit 5, exhibit 25. There is no very different. Yes. Yes, sir.
Yes.
Exhibit this
22.
is exhibit 22.
Sanction.
22. Yes. Yes.
My lord, may kindly, I'll take my lord to the sanction. Whereas it is alleged that the Sambalpur Vigilance PS case number 41 of 15/7/2006 that Sri Srikanta Kumar Mishra, OPS Deputy Superintendent Home Guard Sambalpur, was found to be in possession of assets disproportionate to his known source of income during the check period of 1/01/95 to 2006 12th January, which he could not account satisfactorily. And whereas during investigation it reveals that Sri Mishra, being public servant, committed criminal misconduct in acquiring huge assets during the period 1/1/95 to 2006, found to be disproportionate to his known source of income.
Last paragraph. Whereas the state
Yes.
government of Orissa, after careful examination of the facts stated in SP's report,
Yes.
of the above noted case and further relevant prosecution papers, produce such FIR and so and so, so and so, so and so, so and so. Consider that Srikant Kumar Mishra has committed the offence under section so and so, so and so. Now the government of Orissa do hereby please to accord the sanction under section 19(1)(b). Yes.
Yes.
What are you saying?
Yes. The officer who has initiated this proceeding, my lord.
OSD.
Yes. Who is a retired officer who has superannuated.
Superannuated on 20. He has given it on
5th.
5/4/2011.
Yes. 5/4/2011.
That day he
yes.
was already superannuated.
He was additional secretary in that department, GA. After retiring, he signs this on a special when he was appointed as OSD. 1. 2, my lord.
Show me any document that he when he got superannuated.
Well, the OSD, my lord, is not a post, my lord, at all. Not a post, my lord, which is in cadre, it's ex-cadre. Officer on special duty is an ex-cadre post. He is not in the cadre.
Yes. He was examined as PW?
15.
15. Come to PW 15.
Yes. Take my lord goes there, my lord.
Come to PW 15.
Yes.
Let us see whether you ask this question.
Yes.
To him, what is
5/5. I was working as officer on special duty in Japan. Prior to that
1
date,
minute.
vigilance
Let me read that.
sought for sanction. That's at page 2 to 5.
2 to
5.
2 to 5.
Of volume 2.
Volume 2 to 5. Hey, I have that. 2 to 3 2 to volume 2. Yes, that's there. Yes, read it.
Of sanction for prosecution, the allegations of possession disproportionate asset on 1/9/96 to 2/1/2006. The proposal was processed in the GA department. I held pre-sanction discussion with Sri Parida, DSP, who appeared before me along with the documents in response to the notice against him. On perusal of the documents, I don't kindly see this much. On perusal of this and produced and after discussion with him, I am satisfied there is prima facie case.
He himself is given. He himself is. Right.
And
it's not that he is not acting on behalf of someone.
Of the government, well, not this, the GA department is the one that is to be initiated.
Chief Minister, for details note and submitted the relevant No. Further, you read that. The honorable, it says it is submitted the file along with relevant materials to the Honorable Chief Minister.
Yes.
Through the Deputy Secretary and the Chief Secretary. The Honorable Chief Minister approved the sanction.
Yes.
For the prosecution, and thereafter I signed the
Yes.
sanction order.
Yes, my
on
lord.
behalf of the government.
Yes.
That's the.
I accept it, my lord. What is the material, my lord? There has to be a discussion. The law is no more rescintigra that it has to be looked into. And the one that is in favor of the accused has to be looked into also. Very important aspect, my lord. And the law is no more essential. I'll cite direct judgment on that point, my lord. My lord, he has superannuated. After superannuation, he signed this. There is no opinion, no dispute about this, because officer no special duty cannot be in cadre officer. It has to be the.
Show me exhibit 23.
Yes.
Exhibit 23.
Exhibit 23 is.
See the exhibit 20.
That's a forwarding letter, my lord.
Yes.
Dated 6/4. That's also.
A sanction order is forwarded.
Yes. That's all. And my lord, the law in the subject is very simple, my lord. That every material that is there has to be produced before the sanctioning authority.
Yeah, that's right.
Yes. Because of the seriousness of the matter, my lord.
Yes.
Then this is regarding that, my lord. At the judgments, my lord, I'll cite. My lord, and my lord, may kindly see.
Again, see the cross-examination part.
Yes, sir.
In chief, you said that.
Cross-examination, my lord, there is nothing much, my lord. I do not remember the date of, my lord, this is very important. I do not remember the date on which the pre-sanction discussion was held. During the pre-sanction discussion, I perused the building valuation report, details of personal loan statement, PCE, balance sheet, purchase of tipper, statement of suspected witnesses. My lord, this is where I'm saying that I'll take my lords to the deposition IO, which says something far more interesting, my lord.
Insofar as the competency is concerned, you have not put any question.
No, my lord.
There is no question or any suggestion.
No.
To the.
No, my lord.
You are.
No, my lord. I'm taking this for the first time in the appeal, which I have a right to, my lord. Yes. And I'm only saying that what has to be done, my lord, the secretary has to be, is the person, and they have to, it cannot be so cryptic, my lord. It has to be with details.
Right. Yes.
And my lord, may kindly see, by order of the governor, then he signs as officer in special duty. And he says in deposition that he has given it through the chief secretary, through the deputy secretary and chief secretary, and all of them approved. Chief ministers approved. And this, my lord, is the order of the governor. Admittedly, governor is the appointing authority. What should have been done, my lord? All the details should have been processed and put before the governor. Governor would have gone through that and said that, yes, I'm satisfied on these basis that should do. It's no more res integra that 119 sanction or the 197 sanction, my lord.
Where have you read, governor?
Last exhibit 2 by order of the governor.
Where are you reading?
On exhibit 22. Last, my lord. Signature before the signature.
By the order of the court.
Yes.
And in the chief, he doesn't say anything that it was routed through governor.
No. Chief minister looked at it and it has been sent.
And then from the chief, it comes out that the papers were placed before the chief minister.
Yes. Papers that were made available. That is what I'm stating, my lord. There is an important aspect, my lord. My lord, here is a case where the very investigating agency, my lord, may kindly call for the case diary. My lord, the investigation completed and it was written by the same IO that there is no case that we should put out for here because of the fact that it is 5% of the 5.5% and it should not, we will probably not be able to get a sanction. Even if we get a cancel, it can't test of the scrutiny of the of judicial scrutiny. It cannot withstand.
This is all about your
The sanction, my lord. Sanction and the judgments, my lord, are very clear that if something is there, some material is there, every individual case, the prosecution has to establish and satisfy the court by leading evidence that the entire relevant facts
were placed before the sanctioning.
Yes.
That's the law.
That's the law. And Malad is succinctly put there also. The prosecution must send the entire relevant records to the sanctioning authority, including the FIR, disclosure statements, statements of witnesses, recovery memos, draft charge sheet, and all other relevant material. The record so sent should also contain material / document in any of which may tilt the balance in favor of use on the basis of which the competent authority may refuse sanction. Then, my lord, I'll.
But to the witness, you have not put anything.
No, my lord,
That's
but
the problem.
yes, but they cannot improve anything beyond this.
Now, how will you presume that these documents were not
Yes,
placed before?
that I'll prove, my lord, very easily. I'll prove it right away, my lord.
Because the witness who has come to the witness box, sanctioning
Yes.
authority, who according to you is an expert cadre
Yes.
guy who was sitting there as a OSD. First of all, his competency is one thing. Second is material placed before.
Yes.
But you have not put a single question. No?
Regarding that, my lord, but I will indicate, my lord, that the investigating officer himself says this.
IO, let us see.
Yes.
IO.
Yes.
IO, PW.
PW 17.
Please.
It starts at 236. I'll straight take away, my lord, to
236.
Yes. Straight take away, my lord, to paragraph 102. Sanction, I'll take first, my lord. 247. Sanction point in cross-examination.
236. Yes. Yes. 236.
Yes, ma'am. 247.
47. Yes, 247. Yes.
In this case, I had pre-sanction discussion with the sanctioning authority, additional secretary GA. Let me kindly note that. That is what I was stating, my lord. That it's the additional secretary GA with whom we had a discussion. The man who signs this is the OSD. We, along with all connected documents, including FIR, case diaries, statement of witnesses, statement of the accused, which was seized and collected. I have conducted the investigation of entire investigation in this case. Then, my lord, may kindly see page 102. I'll start. Page 266. Very interesting. Yes. Penultimate paragraph. I'll take, my lord, to the last paragraph.
266.
Yes. 266.
Yes.
Then, my lord, I'll start. It
100?
is page 102.
102.
Paragraph 102.
It is not a fact that I have not taken.
It's not a fact that I have not taken sale consideration of the gold ornaments and so and so. It's a fact that under the SP Rourkela already permission was granted to the accused to purchase the second-hand car by selling ornaments belonging to his wife. It's a fact that I have taken the value of the car towards the accused. It is not a fact that I have taken not taken 70,000 rupees to the income of the accused. That has not been taken, man. I'll prove that. The accused has earned 1 crore 80 lakhs for sale of ornaments during the check period is a fact I have submitted in the report to the SP on 15/1/2008. He says that there is a sale. And that's not very important also. Regarding the progress of the investigation, till the date of my investigation, my lord, may kindly...
Till the date of my investigation.
Very important.
Reveal that during the check period, accused had the income of so-and-so.
Yes.
And his expenditure is so-and-so.
My lord.
And the likely saving is so-and-so. That on that day, the value of the asset during the check period is so-and-so. Thus, DA by then was so-and-so 5.47%.
5.4. And thereafter, how many months later, my lord, this is the further charge sheet is filed is interesting. On 2/6/2009, I submitted a report.
This was regarding the first report.
That's the first report.
Yes.
First report, all the material was collected by him already. There's no material not there. And he has written, my lord, I am saying with conviction, my lord, he has written also, the case diary may be called for, my lord, that my lord can see. I cannot see, my lord can see. Case diary, he says this is not a case which should be asked for a sanction at all, because we cannot sustain the case in the court. Dehorse that, and he himself says this 5 point. This is the 5.14. The chief in the cross is exactly what he has written in that report to the IG, that it is not a case we can initiate.
Let us see in the second report what
Yes.
has come.
On 6/2, my lord may kindly see. On 6/2/2009, I submitted a further report to the SP Sambalpur showing the income of the accused during the check period at 51 lakhs and the expenditure as 20 lakhs so and so, and the likely saving at so and so, and the calculated on so and so.
Come to 38.78.
Yes, 38 point something. Interesting case is next paragraph, my lord. I cannot say what items I included in the assets in my revised calculation. Because their revised calculation was on the same material. How many almost this was this date was which one? This is the date. 15/10/2008 was the first report. 10/10/2008. Second line from the top at 267.
2008, huh?
Yes.
This is the
Yes.
6/9/2009.
6/2/2009 is this report.
Yes.
I cannot say what are the items I included in the assets for calculation. It is not a fact that I have not collected any material documents of income and expenditure and after submission of my report and other. Till making of the charge of investigation successor. These material would be available with my subsequent reports of the SP. It is a fact that the CD, in my case, I am deposing it. Whenever any document is recorded, the same is reflected in CD between. Yeah. This, my lord, the CD itself, my lord, I want my lord to see the CD where the CD itself demonstrates that he himself had written that there is no case to be initiated.
Okay. Show me in the cross-examination.
This is the
What
cross-examination.
What are the materials you have asked him to, whether you have placed it before the sanctioning authority?
Sanctioning authority. Yes, that my lord I had taken.
Have you
my lord.
posed the question? What are the materials he has placed before the
Yes,
sanctioning?
he says that I had conducted the entire investigation. In page 247.
247. That I
My lord read.
58.
Yes.
I read that.
That's all. I had placed FIR, my lord. This is interesting reading, my lord. FIR case diaries, statements of case diaries had been sent. The CD had been sent. The CD contains that. His first report is there, CD.
In that CD, it is written that
Investigation over. I don't find it's not beyond 5.414. I don't know how on earth, my lord, they can destroy a person's life for all
but
time.
that CD entry might be in the month of in the year
No, my lord,
2008.
no investigation between that date and now. That is the interesting point.
No, there is difference between
4 months.
August 2008 and February 2000.
Not an iota of material has been collected after that.
October 2008.
Not an iota, same material. Same material.
Then diary needs to be seen.
Yes, my lord, may kindly see the diary.
15/10/2008
Yes.
and 6/2/2009. What has happened?
Yes, my lord, may kindly see the CD.
Second.
It's a fact that whenever any document is received and statement is recorded, the same is reflected in CD between 15/8 so and so and making witnesses. I've examined some witnesses, namely so and so, so and so.
I think that period you did not make the IO happy. It appears you should have made the IO happy in this during that time.
Well, it is
you didn't made happy, so therefore he filed a second report.
Second report, and that too saying no material. Interestingly, no material. they had closed investigation, and thereafter when his SP posting came, immediately they said that there's an investigation pending.
We'll continue.
Yes, yes. And my lord,
Mr. Das, you have to only answer one thing, that merit I'll subsequently see. The very important thing is you see the sanction order. Sanction order is given by OSD.
No was
1 minute, OSD. That's what I gathered so far.
when the
Minute.
when he adduced evidence, he was overstayed.
Well, anyway, I'm not on that. What he says is it was placed before Chief Minister and he has seen it and given it. And there was a pre-sanction meeting also. But the IO in his examination, cross-examination, examination in chief, not cross-examination, he says that cross-examination in para 58, he says that he says that the pre-sanctioning meeting had taken place with someone else.
After he went to
No. He says that he met with, you can't add to it. Just see what he says. He says that he met with one additional secretary who has nothing to do with the sanction.
another IO is there, BW 16 man. 16. Another IO is there.
No, this.
No, this man submitted charge sheet.
No.
There are two IU. Then I'll see that 16 also.
Yes, 16 I'll take my lord.
16 also. But para 58 he says that he met with the additional chief secretary with sanctioning authority. He has not given the sanction.
I have conducted the entire investigation.
Somebody else has given the sanction.
Oh, who is PW 15 man?
15.
IO?
PW 15, no.
Sanctioning
PW
authority.
15 is the sanctioning authority man. He himself has adduced evidence that I had discussion with the IO. Can it be taken that he has not discussed with the IO? PW 15 you
No.
Discussion of
IO, I'm reading the IO statement, sir. IO statement.
IS officer is an IS officer. He has stated adduced evidence.
No, it's PW. I'm reading PW 17.
No, PW 25, 26.
PW 17 I'm reading. PW 17 is the DSP who has conducted the investigation. And he says that I had a pre-sanction discussion with the sanctioning authority. That is the additional secretary, GA department. Held on 16/2/2010. During the discussion, all the relevant documents were given to him.
Yes.
And this gentleman, the additional secretary, GA department, is nowhere in the picture when in this entire sanctioning story. Sanctioning order, some OSD has given.
Sanctioning order exhibit 22 is there.
Yes.
Yes, I read.
By the order of governor, it has been given.
By order of the governor signed with the OSD.
Chief Minister discussed who was the control.
Unfortunately.
So what he is trying to argue is the materials will not place before the people, those who have really dealt with the sanctioning business. It was see the sanctioning business, whatever sanction you have got, you place the material before someone else is giving sanction. That's what is case.
I have not examined.
That's what doubting.
That is what
That's what your answer.
Sanctioning authority.
My lord,
Say whatever. The materials has to be placed before him. He says that the materials were not there before me. And the IO says that I have placed the material with someone else. And the bunch of file is moving here and there. Somebody else is given.
If the sanctioning authority would not have been examined as a witness, when the sanctioning authority has been examined as a witness and speaks the truth that I had the discussion by naming this particular witness BW 17, his name has been indicated.
Yes.
Swarup Kumar Parida.
But if IO says that I have never met him, where if it goes to this, there is a doubt. IO says that I have not met with the sanctioning authority. Sanctioning authority says yes, I have met with him.
He has not stated so.
That's what the evidence is looking at.
Stated that he had the discussion in chief, your lordship may kindly have a glance.
But IO says that I have never. IO says I have never met him. IO says that I met someone else.
No.
Additional secretary, GA department.
In the chief, he has stated so that I had discussion with the sanctioning authority with all the materials.
According to him, according to IO, the sanctioning authority is the additional secretary, GA department. That's the problem. He conceived that the sanctioning authority is that gentleman who is working at the additional department.
I will clarify that.
That you
Yeah.
clarify that.
And
This
my
is
lord,
what has now you will clarify and think.
My learned friend was saying about the PW 16. My lord, PW 16, there's an interesting reading. I have not examined any witness in this case except Dhobbai Chandra Sahu. That is that Dhobbai Sahu.
Sanctioning authority.
See, came sanctioning of the Dhobbo.
There is a something, very doubtful. Have you just address on this?
Regarding sanction, I will clarify.
If the sanction goes, everything goes.
Yes,
And my lord,
We need not go into
I will cite this.
first you satisfy on sanction. If the sanction goes, then we need not get into all this thing. Why to waste time?
Yes.
Yes.
My lord, the case diary may be called for, my lord, in the meantime. So that
From the record, it will be.
It will demonstrate on record. Also.
We'll see.
It has to be available.
There are many documents. We don't know what are the documents. Your junior has to look through this file, paginate it,
yes,
so that it will be easier next time. And whatever pagination you are doing, also.
Yes.
So that yes.
Yes.
Mentioning something.
Fixing a date, my lord.
73.
Huh?
Item 73.
Let it be there on the board. We'll see. Let it be there. I will not.
My lord, fixing a specific date, it subject to.
He has a problem.
Any date, my lord, may give.
He met with an accident.
No, I have no problem, my lord. His colleague has met with an accident. He's the brother.
Now, therefore, it has come to him.
Yes, he's my brother-in-law and he's my brother. So.
And in the money line,
23rd.
But he has, especially this matter is fixed anyway. You got an overall idea now.
Yes.
You now can address easily. Instead of going here and.
My lord, call it 22nd.
22nd
or 21st?
22nd or 23rd?
23rd is Friday.
30th.
Thereafter.
30th. Friday.
No, don't make Friday. That's the last Friday. Again, the reference and all that business will be there. Yes.
28th, my lord.
28, 29.
All right.
28th.
28th is all right.
28th.
One.
Item 72.
Deep blue.
The rest of the thing will remain in the board.
Interim order.
Lord, one
interim
small
order.
request.
Let it be there in the board. When I get the time, I will pick up the file.
Interim order.
That's a better idea. Don't disturb the list. Supplementary list, any matters?
This is the supplementary list.
Then it has to be listed tomorrow. Listed tomorrow? At the
Will be on the top and everything.
At the end?
That can.
At the end? After miscellaneous matter, the remaining matter you list so that whoever is there, if you get time, many a time board collapse, then we will pick up.
Lord, one small request, my lord.
Yes.
One case your lordship has asked me to, my lord, do the case criminal appeal matter, my lord. That is posted to 13th, my lord. The office has not yet supplied me the paperwork.
What is happening? Why you are not supplying paperwork? Am I case appointed? Why you are not?
My lord, 2 times I went to the office. The file has not come back.
To send get a pen drive, you take everything. That's what.
No, paper book has been prepared. So paper
Already
book.
prepared paper.
Your lordship directed the office to serve the paper book copy on me.
If paper book is there, it will supply.
My lord, probably that has been prepared. So your lordship directed the paper back.
Prepared, give it.
Yes.
The support order is there.
Paper book is there or not?
Bhai,
First.
whatever.
If paper book is there, I give a direction.
Yes.
If
That
it's
is
not there,
criminal appeal number 359 of 2015.
in case it is there, then release it tomorrow itself. I'll pass. Supply a paper book. There should be a judicial order. Na? If it is paper book is there, release it tomorrow. I'll pass the order. Otherwise, pen drive. Okay. Thank you.